Section 235. Examination of depositions, evidence, and the entire proceedings before the committing magistrate. As before intimated, we rather lend our approval to this rule, which seems to have prevailed quite extensively, and to have stood side by side, in some of the states, with the more rigid one akin to that of the common law. In this rule, as well as in the other one, the question of jurisdiction is always open. In fact, one of the first and necessary elements of a valid commitment is the existence of jurisdiction to pass the sentence of commitment. If this jurisdiction does not exist, the prisoner should be discharged. We believe that inquiry should always be open as to the merits of a commitment made by a court or magistrate of special or limited jurisdiction, and before indictment or information filed. The jurisdiction of courts of special or limited jurisdiction should always affirmatively appear, which, however, is not the case with courts of general jurisdiction. In a commitment made by an inferior court of special and limited jurisdiction, or a justice thereof, it should state some act constituting a crime. Unless such an act is charged, there is a failure of jurisdiction. So should it appear on the face of the procos that there was no jurisdiction of the person, the process is void, or if the arrest was made without the territorial jurisdiction of the court, or if the prisoner was carried before a remote justice when there was one nearer before whom he ought to have been carried. In fact, it seems necessary for the court to look beyond the warrants and into the affidavits to see whether the committing magistrate had colorable jurisdiction. In all cases in habeas corpus proceedings previous to indictment, the court will look into the depositions before the magistrate or before the coroner's inquest, and though the commitment be full, and in due form, yet if the testimony proves no crime, the court will discharge or bail. This practice prevails, of course, where no statute exists allowing a commitment to be set aside on motion for any specific cause. But where the statute is delinquent, the prisoner may look for relief to the writ of habeas corpus. Courts and judges should have, and do have to a great extent where this rule prevails, authority to revise the cause of commitment, and to examine into the truth of the facts alleged in the return, and the officer may examine into the merits of the commitment, and hear the allegations and proofs arising thereon in a summary way, and dispose of the party as justice may require. This is neither an impartial rule nor one which imposes onerous duties upon habeas corpus courts. The rule works well both ways. If the warrant alone is to be examined on its face, one innocent of any crime whatever might be compelled to stand his trial if the warrant was regular and valid, and on the other hand, one guilty of even the basest felony would be entitled to discharge if the warrant happened to be void or invalid even on its face. The doctrine of looking behind the commitment of the magistrate protects alike the interests of the accused and of the Commonwealth. Where one has been committed for a felony, the court of original jurisdiction will look into the depositions, or otherwise inquire whether an offence has been committed, and bail or remand according to the exigencies of the case. In such a case it is never a matter of course to let the prisoner to bail, much less to discharge him, but he may, if brought up before indictment, insist that the depositions taken before the committing magistrate be looked into, as a part of the documentary authority on which the commitment was founded. For this purpose copies may be brought up by certiorari. But even here, if the court ascertain that there is no pretence for imputing any indictable offence to the prisoner, the court will discharge him, notwithstanding the opinion entertained by some judges that it is beyond the domain of their duties to sit as an appellate court to review the sentences of connoissing magistrates. It is undoubtedly the intention of the law, as found in the statutory provisions, to give an individual committed for a crime by an examining magistrate an appeal from his commitment to the higher judges by virtue of the writ of habeas corpus, and where this second rule prevails, it seems to be in harmony with every principle of law and justice. It is true that the jurisdiction of the higher court over the process of the primary court is only collaterally appellate, this being the very reason why the writ of habeas corpus, in itself, cannot have the effect of a writ of error or certiorari. For the verification of most of these propositions, laid down as law by Mr. Justice Edmonds of New York, consult the following authorities. In New York, upon habeas corpus to inquire into the detention of a defendant arrested on civil process, the judge was held empowered to examine into the legality of the warrant in question, and the arrest or detention under it, and could discharge the prisoner if the case was one in which the process issued would not be allowed by law. So in another instance, it was held that additional proof might be offered and received to the return on the hearing of a habeas corpus, and before indictment, of the facts stated in the affidavit alleging the crime upon which the defendant was committed before the magistrate. And again, upon application by habeas corpus and certiorari for the discharge of a defendant from arrest, it was held that the court must determine the case upon the testimony taken before the committing magistrate, and that if, upon such testimony, there was a want of probable cause, it became the duty of the court to discharge the defendant. Recorder Riker, at the City Hall of the City of New York, also decided in an early case that the commitment of the committing magistrate was not conclusive, and on the return to a habeas corpus that one was held as a slave, inquired into the fact as to whether the person was a slave or not. In Pennsylvania, the Court of Quarter Sessions followed this rule in 1875. 3 years prior to rendering a decision according to the first rule mentioned, and examined, in a hearing on an application for a writ of habeas corpus, not only the proceedings, but the evidence, and held that the Commonwealth was not required to show the offence beyond a reasonable doubt, it being enough if the evidence was sufficient to warrant the court in saying that a verdict thereon would not be without evidence to sustain it. The Supreme Court of Iowa have held in a very recent case that the waiver of a preliminary examination before the committing magistrate will not deprive the defendant of the right, in a proceeding by habeas corpus, to introduce testimony for the purpose of showing that he is not detained upon sufficient evidence to sustain the charge made against him. The court also determined that a warrant of commitment issued to the sheriff of the county in which the examination is held will authorize the detention and custody of the prisoner by the sheriff of the next most convenient county having a jail. Section 236. Effect of statutes on these two rules. The 58th section of the Habeas Corpus Act of New York provides that if the prisoner appear to have been legally committed for the offence, or if he appear, by the testimony offered with the return or on the hearing, to be guilty, the court shall remand him, etc. This has been held to contemplate an examination of the evidence returned by the magistrate, or of evidence offered on the hearing, and allow such evidence then to be received. And where the court on the hearing sees fit to discharge the prisoner, if the district attorney has the necessary evidence, he can apply for a new commitment on such proof, and the court will commit the prisoner anew thereon. Where the district attorney offers to supply defects in the evidence, and produces sufficient testimony to fully establish the guilt of the prisoner, the court will not countenance a discreditable administration of justice by discharging him from custody. In 1877, it was held, under Section 672 of the Code of Kansas, Gen. Stat. 1868, p. 763,4 that the judge or court issuing a writ of habeas corpus, on a petition alleging that the individual in whose behalf the writ is sued out is imprisoned without probable cause, might subpoena the prosecuting witness, investigate the criminal charge, and either discharge, let to bail, or recommit the prisoner, as law and justice required, although there was no defect in the charge or process. The case of the People v. Tompkins, cited above, was approved by Chief Justice Horton of the Supreme Court, who said, "This section gives a party committed for a crime by an examining magistrate an appeal from his commitment by virtue of the writ of habeas corpus." So in Florida, a man threatened to do bodily harm to plaintiff and to do damage or injury to personal property, but not that mentioned in the statute, as threatening to burn a dwelling. Boise, on a complaint setting forth his threats, he was sentenced to imprisonment by a committing magistrate, for want of sureties against doing damage to the property, and to keep the peace toward the complainant. On writ of error this was held erroneous. With the exception mentioned in the statute, sureties of the peace against doing damage to property were not authorized, either at common law or by statute, and imprisonment for want of giving such sureties was not allowed by law. And the commitment having been made for want of bail for an act not criminal, and also for one criminal, was adjudged irregular, and it was said by the Supreme Court that the security should have been fixed according to the degree of the criminal act charged, and that the primary court on habeas corpus, if required by the accused, should have heard and examined into the evidence for the purpose of determining what criminal act had been committed, and what probable cause was shown against the accused, whether the warrant of commitment was regular or irregular, because in that state the circuit judges are invested with the authority of committing magistrates, and the statutes relating to habeas corpus give ample power to examine into the cause of the imprisonment, and to discharge, admit to bail, or remand to custody, as the law and the evidence shall require. Generally, no doubt, where statutes similar to the above are in force, and where no provision is made by statute to set aside commitments or informations for specified causes on motion, the second rule we have mentioned above is given full scope, and where the above-mentioned similar statutes do not exist, and none to authorize the setting aside of commitments or information on motion, we believe, as before stated, that the better practice and the better reasoning sustain the doctrine of allowing a full enquiry into the proceedings and evidence before the committing magistrate. Section 237. Guilt or innocence of the prisoner. Following up the doctrines laid down in the preceding sections of this chapter, and under the statutory limitations there mentioned, we propose to show in this section that the better rule is that before indictment the whole question of the prisoner's guilt or innocence may be examined by the habeas corpus court. It is frequently said that this subject is not open to inquiry, and M. C. Lyod's case, 1 Hill, 394, is cited as an eminent authority, but Mr. Justice Edmonds, of the Supreme Court of New York, shows that the language of Mr. Justice Kine in that case is entitled to no such binding force, as that point was not before the court, and the dictum was a biter. Said he, the question raised there was, whether, after indictment, the court on habeas corpus would entertain the question of guilt or innocence, and on that question the authorities had been very uniform that it would not, and for very plain and simple reasons, that as the testimony before the grand jury would not be written and could not be looked into, the court or officer on the habeas corpus could not ascertain on what evidence the grand jury had acted, and could not entertain the question without receiving precisely the same testimony which the jury would be obliged to receive on the trial, and thus, in fact, usurp the province of the jury. Hence, it had been the practice of the English courts and our own, which was followed in the MacLeod case, not to look into this question of guilt or innocence on habeas corpus, after indictment. But not so where the party was committed by the magistrate, nor even where he was committed on the coroner's inquest, because there were depositions which could be looked into. His Honour, after citing several instances which were exceptions even to the rule that the commitment may be inquired into after indictment, said he did not understand this rule, whether it had few or many exceptions, to deny the power after indictment to look beyond the commitment. It merely says that the court will not that it cannot do so, and for very good reasons, as I have already mentioned. For equally good reasons it may and does do so, as is shown by the many cases where, after delay to bring on the trial of an indictment, the party has been discharged or bailed. 1. In Alabama is this doctrine the practice under their code. In the words of Justice Stone, we think a prisoner who is in custody simply on a warrant of commitment, issued after preliminary examination and before any indictment has been found, can, when brought on habeas corpus before a proper officer, claim as a matter of right that such officer shall hear and pass on all legal evidence which he offers touching the question of his guilt. If, on such examination, it appear that no offence has been committed, or that there is no probable cause for charging the defendant therewith, the prisoner must be discharged. If it appear that an offence has been committed and there is probable cause to believe the defendant is guilty thereof, the defendant must be bailed or committed, as the law directs. In determining, as stated above, that prisoners can claim as a matter of right to have their witnesses heard, we think we are giving effect to the following provisions of the Code, 1852. We do not, in thus laying down the rule, intend to declare that there are not other cases in which witnesses should be heard. They are always heard, if offered, on applications for bail, and there are doubtless other cases of controverted fact where such practice would be proper. This case was cited and approved by the Supreme Court of Alabama in 1875. The prisoner, by petition to a probate judge, showed that he was restrained of his liberty in the jail of Pike County by the keeper thereof, upon a commitment of a justice of the peace, charging him with having committed rape, and sued out a writ of habeas corpus to be brought before said judge to have the matter determined. The petition was demurred to, principally on the ground that it did not appear from the petition that the prisoner was illegally restrained of his liberty, but rather the contrary. The judge sustained the demurrer, dismissed the petition and writ of habeas corpus, and refused to hear any witnesses touching the guilt or innocence of the prisoner, or to inquire in any way into the cause of said imprisonment or restraint, to all of which the prisoner accepted. On mandamus to compel said judge to hear and determine evidence in regard to the matter, the Supreme Court said that Section 4262 of the Revised Code did not require that the petition should set forth that the prisoner is illegally restrained of his liberty, in addition to the averments made in it, which were exactly the ones prescribed by the Code. The petition was verified. Of course, says Mr. Justice Manning, though this must be shown by the evidence before the magistrate that issued the writ of habeas corpus would be justified in discharging the prisoner unconditionally. But is the petition demurrable because it does not assert the innocence of the prisoner or declare that he is illegally held in custody? By Section 4261 of the Code, the petition in such a case must be sworn to, and the humanity of our law is such that not only is a person held to be innocent until by some judicial proceeding he has been ascertained to be guilty, but the Constitution further provides that he shall not be compelled to give evidence against himself, or be deprived of life, liberty, or property but by due process of law. To require of a prisoner, therefore, in the petition in which he sets forth that he is restrained of his liberty, and by whom, and where, and on what pretense he is so restrained, to say in addition that he is illegally restrained, and make oath thereto, might be an infringement of his constitutional right to stand unquestioned and presumably innocent in the presence of his accusers. The petition, therefore, was not subject to the demur interposed by the solicitor, and the judge of probate erred in sustaining it and in thereupon dismissing it and the writ of habeas corpus. After showing that the evidence should have been received and passed upon, he continued, of course on such an examination, the judge making it should be careful to see that the proper legal steps be taken to get all the evidence on the question of the prisoner's guilt. And if the latter had been committed, after a prior investigation by an officer authorized by law to make it, the prisoner ought not to be discharged, without all the witnesses that had been previously examined against him, if still living and attainable, being produced and examined. In the absence of any material witness who previously testified in the examination against him, the question for consideration should relate only to the amount of bail, if the case be bailable, and if it be not, the prisoner should be remanded by the judge into custody, to be kept safely until discharged by due course of law. Great strictness in the forms of proceedings are not required in cases of habeas corpus. A rule nisi why the writ of mandate should not issue was granted. Section 238. Commitment by court of general jurisdiction. Where a defendant has been arrested and imprisoned in a civil case, by virtue of a warrant issued by the judge of a court of general jurisdiction, another court or judge will not disturb the commitment if the judge making it had colorable jurisdiction. In such a New York case it was said in the decision of Mr. Justice Mason, on proceedings by habeas corpus before the Supreme Court, that the court, or a majority of the judges, are decidedly of the opinion that in this case we cannot review the regularity of the proceedings had before His Honor, Judge Edmonds, one of the justices of the First Judicial District and of the Supreme Court, who had issued 2 of the warrants, the other 3 being issued by a justice of a superior court, and that upon the writ of habeas corpus we cannot look beyond the colorable authority of the judge to issue the warrants. We cannot inquire into the technicalities or the strict regularity of the proceedings. This writ is not intended to review the regularity of the proceedings in any case, but rather to restore to his liberty the citizen who is imprisoned without color of law. In these cases we can merely look into the sheriff's return, which contains the several warrants by virtue of which he detains the relators, and also into the affidavits contained in the traverse, and upon which the judge issued the warrants, so far as to see that the judge had colorable jurisdiction. Or in other words, if we find that the judge had jurisdiction of the process, and assumed to take proof upon the issuing of the same, and which proof he adjudged to be sufficient, We will not, upon the writ of habeas corpus, review his adjudication upon that question, nor undertake to say whether he erred in adjudging the proof to be sufficient. In looking into the warrants under which the present relators are imprisoned, we find them regular upon their face, and prima facie sufficient to justify the imprisonment. And when we come to look beyond the warrants, and examine the affidavits upon which they were issued, we are satisfied that at least there was colourable proof, in these cases, before the judge, upon which he might exercise his judgment in awarding the process. And this is as far as we intend to go in these cases. But in ordinary criminal proceedings commitments are seldom made, comparatively speaking, by courts of general jurisdiction. By statute, however, in some of the states the judges of the courts of general jurisdiction are made magistrates and are vested with authority to hold accused persons to answer. Commitments made by these magistrates are undoubtedly entitled to more consideration than a commitment made by an ordinary justice of the peace. These magistrates being vested with authority to hold accused persons to answer does not divest them of the power of passing upon the sufficiency of their own commitments as courts of superior jurisdiction. The one judge exercises the functions of two separate and distinct officers. The commitment is made by the judge as a magistrate and approved by himself as the judge of a superior court. Consequently, these commitments should not be reviewed by other superior courts of coordinate jurisdiction, or even by the Supreme Court, except for want of jurisdiction. And even proceedings for a review by the Supreme Court, to investigate that question, ought not to be entertained because the commitment was made by a court of general jurisdiction, and the jurisdiction of those courts will always be presumed. In some of the states the Supreme Court, the superior or district courts, and other courts of general jurisdiction, are all on the same base, so far as their authority, power, or jurisdiction is concerned, relative to proceedings on habeas corpus. They have the same powers, the same authority, the same jurisdiction. The statute has invested them all with the same panoply of power, and neither sustains to the other the relation of a superior or an inferior court, in the same sense that a district, superior, or Supreme Court is superior to a court of the justice of the peace or other court of special and limited jurisdiction. The word superior or inferior can with no propriety be applied to the jurisdiction exercised by either. It is in each the same, one and identical. Therefore, to ask one of these tribunals to review the commitment made by another would be in reality a sort of collateral appeal from a jurisdiction to itself, and where the officer returns such a commitment, or the warrant upon which he holds the party, if the warrant is good upon its face, the inquiry should extend no further, because the commitment has been made by a court of general jurisdiction, and one court of general jurisdiction should not review the proceedings of another on the writ of habeas corpus. The principles of comity should prevail. In a late California case, the petitioner for a writ of habeas corpus had been convicted for killing one man. On appeal a second trial was ordered, and after both the prosecution and defense had introduced their evidence, the district attorney moved the court that the jury be discharged from the further consideration of the case, on the ground that it appeared from the evidence that an offence of a higher nature than that charged in the indictment had been committed. The indictment, as it then stood, was for manslaughter. The court granted the motion, and made an order that the defendant be committed to answer any indictment which might be found against him for murder. On habeas corpus, the Chief Justice of the Supreme Court said, the order was made by the district court, the judge of which court is a magistrate vested with authority to hold accused persons to answer. Penal Code, Sections 808-874, and was entered after hearing the evidence touching the alleged killing of Madden by the prisoner. Whether the order was irregularly entered, was erroneous, or what defense or advantage it may possibly afford the prisoner, should he be again put upon his trial for the killing of Madden, are questions which it is not the office of a writ of habeas corpus to present for our consideration. His Honor referred to and approved of the observations in Ex parte McCulloch, 35 California 100. Section 239. Cause for detention after failure to indict. Where a statute provided that, when a person has been held to answer for a public offense, if an indictment be not found against him at the next term of the court at which he is held to answer, the court shall order the prosecution to be dismissed, unless good cause to the contrary be shown. Mr. Justice Wallace, of the Supreme Court of California, in discharging a prisoner under it, presented the law in the following manner: the case in which a dismissal of the prosecution is not to follow upon the non-presentment of an indictment against the accused is exceptional. The accused has a right to depart, unless good cause to the contrary be shown. This general provision of the statute, that the prisoner is not to be held indefinitely, is designed to secure to him a speedy trial, and this right is absolute, except some good cause be shown which may be supposed to take the case out of the operation of the general rule. What is good cause, may be difficult to define with precision, since it must in a great measure be determined by reference to the particular circumstances appearing in each case. There should, undoubtedly, be some fact or circumstance disclosed to the court upon which its authority in this respect, somewhat discretional, could be brought into exercise. Its discretion is not to be arbitrary, but should proceed upon such knowledge or information as would enable it to determine for itself whether or not public justice requires the further detention of the prisoner, notwithstanding the delay upon the part of the prosecution. It must be admitted, too, I think, that ordinarily this discretion, when exercised by the court to which the law has entrusted it, is not subject to review, and that when exercised, the sufficiency or insufficiency of the grounds upon which it proceeded could not be examined here through the instrumentality of a writ of habeas corpus. The presumption that the discretion had been correctly exercised would ordinarily arise, if the record should state in terms that good cause appeared. So, too, if the record should recite a particular fact, or several facts, as being the facts upon which the court had proceeded in ordering the detention of the prisoner, the import of such fact or facts as being sufficient or insufficient to amount to good cause would not be accurately weighed in this proceeding. It would rather be presumed that there were other existing facts not affirmatively disclosed upon the record which would support the action of the court in making the order. But in the case before me there can be no doubt that the circumstance upon which the court acted in detaining the prisoner was in itself wholly and absolutely insufficient to support the order. The grand jury just discharged had recommended that the prisoner be detained, therefore he was detained. The record, too, states that the detention was without further or other cause than said recommendation being shown by the district attorney, so that there is no room there for the indulgence of a presumption of the existence of some other insufficient ground upon which the order might be supported. The grand jury seem in this instance to have assumed the exercise of the discretion which belonged alone to the court, and the court seems to have made the order in mere deference to the expressed opinion of the grand jury, and without any investigation or information concerning the circumstances of the case before it. The statement that the order was made for no other cause than the mere presentation of this recommendation is equivalent to the recital upon the record that no good cause, no cause at all was shown, and where that condition appears, there is no power to detain the prisoner. This case was cited, followed, and approved in Nevada in 1876, on an application for a writ of habeas corpus before Chief Justice Hawley, at Chambers. The petitioner had been committed to answer a charge of murder. The grand jury found no bill against him. The judge of the district court ordered that he, with others, be held to appear before the next grand jury of Nye County, Nevada, upon sufficient cause having been shown the court why the case of the state of Nevada against said parties should be resubmitted to another grand jury. The prisoner, on the next day, applied to the judge of the district court to be admitted to bail, which application was denied. He then sued out a writ of habeas corpus, alleging that the above facts showed his restraint and confinement to be illegal, and asked to be discharged on his own recognizance or admitted to bail. The statute in that state was identical with the one above mentioned in California. His Honor presumed that sufficient cause was shown, and in the absence of any showing to the contrary, was also bound to presume that the district court did not act arbitrarily in the premises, and having been charged with murder and committed for that offense, petitioner was not entitled to bail where the proof was evident or the presumption great. Ordinarily, said he, the fact that a grand jury has investigated the charge and refused to find a bill ought to be sufficient to satisfy a court that the proof is not evident nor the presumption great, but notwithstanding such action upon the part of the grand jury, the court, in a case like this, would have the right, and it would be its duty upon the application of petitioner, to hear the testimony and decide for itself whether the proof of the defendant's guilt was evident or the presumption great. This is a question upon which courts and judges are invested with a legal discretion, which is at all times to be exercised with sound judgment upon a full consideration of all the facts and circumstances of each particular case, and when it appears that the presiding judge has acted, no other judge would be warranted in discharging the petitioner or admitting him to bail, unless it clearly appeared that the presiding judge had acted arbitrarily in the premises, and thereby abused his discretion. The writ was denied. Section 240. Convictions by inferior courts. The rule permitting a liberal inquiry into commitments made by courts of special or limited jurisdiction is much stricter after final convictions by those courts, where, by statute, they have power to try and convict for certain offences. After trial and conviction, these courts, of course, make a commitment, but it is of higher dignity than an ordinary commitment holding to answer. It has some of the elements of a final commitment to prison by a court of general jurisdiction, and the judgment or sentence of an inferior court, after trial and conviction, is entitled to more consideration than its sentence of commitment simply holding to answer. Its judgment is placed, to a great extent, beyond the reach of collateral attack by the writ of habeas corpus, as judgments of higher courts are. Where an inferior court has jurisdiction to try and pronounce sentence, its judgment, generally, should be regularly and directly attacked, when the object is to avoid its effect. Another reason why the convictions of inferior courts are entitled to more consideration than their mere commitment holding to answer is, that the power to try and convict is conferred upon them by statute, and which it is presumed they will follow in the exercise of a wise discretion, while, in ordinary examinations, although the power to hold them is also conferred by statute, the magistrate is only to be satisfied that there is reasonable or probable cause to believe that a crime has been committed, and that the prisoner is the one who did it, and having no further power over the defendant than to put him upon his defense to an information or indictment which is tried in a higher court. To illustrate by some New York cases which may more properly belong to the chapter on impeaching judgments by habeas corpus, yet, as that chapter will be very full, they may be spared here to elucidate the subject under consideration. John B. Bennack was convicted by a justice of the peace of being a disorderly person, and was committed to jail in default of giving bail for his good behavior. On habeas corpus the circuit judge refused to discharge him from custody. On certiorari to the circuit judge from the Supreme Court, to review his decision, the Supreme Court, by Justice Willard, said, among other things, the counsel for Bennack did not traverse the return of Crosset, the constable, to the habeas corpus, or allege any fact and the return to show either that the imprisonment was illegal or that he was entitled to his discharge. Conceding that the prisoner was restrained of his liberty by a public officer, by virtue of process issued by a magistrate of competent jurisdiction, his counsel contended that he was entitled to his discharge, for the reason that the warrant, on its face, showed that no offence had been committed for which he was liable to be imprisoned. If this be true, no doubt the circuit judge erred in remanding him. It was for the prisoner to make out the jurisdictional defects, either by testimonial and the return or by the process itself. He took the latter course alone. If, then, there is enough on the face of the process to protect the party who issued it or the officer who served it from an action of trespass or false imprisonment, in short, if it is not absolutely void, the decision of the circuit judge should be affirmed. A warrant issued upon the conviction of a party as a disorderly person is not required to recite any fact but such conviction. It was insisted, however, that the recital in the warrant of commitment afforded evidence of the testimony before the justice upon which the conviction was founded, and that testimony did not authorize the conviction. In answer to this, it may be said that the warrant was complete without reference to the facts recited. It described the offense, conviction, and sentence, and this is all that was necessary to its validity. It thus appears that the magistrate had jurisdiction both of the person and the crime. The recital of the facts proved before the justice was not required, nor can they be regarded on a habeas corpus. It does not appear that the facts recited were all the facts proved or admitted. To discharge the accused because the recited facts would not warrant a conviction would be to retry the cause on the merits in this collateral way. And it would be a retrial without any assurance that the whole facts were spread out in their warrant. This cannot be done. If the justice convicts upon insufficient evidence, the remedy of the party injured, if any, is not by habeas corpus. If, then, we are to regard the facts recited as affording the evidence on which the magistrate acted, still they present no ground for a discharge. While the conviction remains in force and is not absolutely void, their warrant will authorize the arrest and imprisonment of the accused. And the conviction cannot be attacked but by a direct proceeding, such as a writ of error, certiorari, motion to quash, etc., according to the nature of the case. The proceedings of the circuit judge were affirmed. Several convictions as vagrants were also examined on habeas corpus, the above principles being applied. One was before Honorable Josiah Sutherland, of the Supreme Court, at Chambers. Catherine Forbes had been convicted as a common vagrant by a police justice, on proof that she was a common prostitute and an idle person, but without proof of any other fact or circumstance. Under the statute, the judge considered that it was only a certain class of prostitutes, those without employment, who were declared to be vagrants, and said, I have come to the conclusion that the warrant of commitment on its face is absolutely void, and that the prisoner must be discharged, on the ground that it does not appear on the face of the commitment that the prisoner has been duly convicted of being a vagrant, or indeed, that she has been convicted or committed for any offense or crime whatever, as no statute of that state had declared common prostitution or idleness to be a crime. In connection with this, a perusal of Carney's case will be instructive. It will be observed in these cases that there is a want of jurisdiction, fatal defect, because no offense is charged which is known to the law, and a prisoner always has a right on habeas corpus, even by proof alund, to show that the court or magistrate acting as a court, who tried and sentenced him, has no jurisdiction. Another case came before Justice Ingraham, of the Supreme Court, at Chambers. The prisoner had been committed as a vagrant by a police justice. His Honour thought the practice of reviewing such convictions on habeas corpus was not to be commended, as the statute provided another mode for correcting errors of the justice which should be resorted to, and that if the commitment was regular, and the justice had jurisdiction of the matter, no relief should be afforded in such proceedings. It was enough if the offence of being a vagrant was charged, and that the prisoner was convicted on competent proof. It was sufficient if the commitment followed the record. It did not require that the justice should insert in the record the particular grounds on which the charge of vagrancy was based, and it could not be necessary to recite them in the commitment. He concurred with the views of Mr. Justice Sutherland, in the case of Catherine Forbes, so far as they were expressed as to what was necessary to be proved in order to make out the offence, and, said B, unless on a review of the case it should appear that all the facts necessary to constitute the offence are proved, the conviction should be reversed, but as I do not consider that all such facts should necessarily be recited in the commitment, I feel bound to remand the prisoner, on the ground that the commitment is regular on its face, and the decision of the justice cannot be reviewed in this proceeding. The prisoner was remanded. So was it determined in the New York Court of Common Pleas, at Chambers, that proceedings prior to a commitment for vagrancy could not be reviewed on habeas corpus, if the commitment was regular, and the record of conviction was properly made and filed. In this case before Justice Ingraham, Dye said, if the allegations contained in the petition are true, injustice may have been done to the prisoner. It is there alleged that she was prohibited from producing witnesses on her own behalf, and from cross-examining witnesses produced against her, and that she is innocent of the charge made against her. But the guilt or innocence of the prisoner cannot be inquired into upon habeas corpus after conviction. If there is any remedy and that there should be one, no one can doubt it is by the Supreme Court on certiorari. I have no power in this proceeding to review the correctness of the decision of the magistrate. The prisoner was remanded and the writ discharged. Section 241. Vacating orders of court. Where a court making an order in a cause bars jurisdiction of the whole subject matter and of the parties which it concerns, it is not competent for another court, under proceedings by habeas corpus, where the process upon which the petitioner is held is valid upon its face, to inquire into and determine whether or not the order of the court upon which the process is founded is erroneous. The power of the court of inquiry extends no further than to declare whether the order is void for the want of jurisdiction, or the process invalid upon its face. This may be shown thus: a lawful judgment had been recovered against petitioner, and an execution issued against his property. He held a paid-up life insurance policy, which he refused to deliver to the sheriff in satisfaction of the execution, on the ground that it was exempt under a statute concerning life insurance policies. On proceedings supplementary to execution, taken and pursued in a regular manner, the court in which the judgment had been rendered made a final order requiring the petitioner to deliver the policy in satisfaction of the execution, and on his refusal to obey the order, committed him to the county jail until it should be obeyed. Chief Justice Sanderson of the Supreme Court of California, at Chambers, said, "In my judgment, his order is not void, nor his process invalid. The prisoner was remanded. Habeas corpus," said he, "is undoubtedly the proper remedy for every unlawful imprisonment, both in civil and criminal cases. But an imprisonment is not unlawful in the sense of this rule merely because the process or order under which the party is held has been irregularly issued or is erroneous. Process which has been irregularly issued may be set aside by the court or officer by whom it was issued, and erroneous judgments and orders may be reversed on appeal or writ of error. The writ of habeas corpus has not been given for the purpose of reviewing judgments or orders made by a court or judge or officer acting within their jurisdiction. To put it to such a use would be to convert it into a writ of error, and confer upon every officer who has authority to issue the writ appellate jurisdiction over the orders and judgments of the highest judicial tribunals in the land. County judges, though occupying an inferior position, and exercising an inferior jurisdiction, would be, by such a rule, empowered to review and practically reverse the judgments and orders of the district courts, and of the Supreme Court itself, and also of the federal courts exercising jurisdiction within the state. Establish the doctrine that the judgments and orders of courts may be reviewed on habeas corpus, upon the ground of error, and appeals for the corrections of errors may be dispensed with in all cases in which the arrest or imprisonment of persons is allowed. Every criminal action, every civil action in which an arrest is given, and every proceeding for a contempt could be brought to the Supreme Court by writ of habeas corpus. Not only that, but, as already suggested, inferior tribunals would be called upon to review the judgments of superior tribunals, and tribunals of equal grade to interfere and review each other's proceedings. Such a rule would render all judicial proceedings amorphous, and lead to the utmost confusion and disorder. It is well settled that habeas corpus can be put to no such use, and that its functions, where the party who has appealed to its aid is in custody under process, do not extend beyond an inquiry into the jurisdiction of the court by which it was issued, and the validity of the process upon its face. In deciding upon a question of false imprisonment, raised under a writ of habeas corpus, the judge may investigate the validity of any order of court relied upon. Thus where apprentices apply for a writ of habeas corpus, and the respondent sets out an order of court binding the petitioners to him, the order of the court should be produced and shown as authority, but the petitioners have the right to reply that the order is void. This they may do either by showing that they were not such persons as the court had the power to bind out at all, or that they had no notice of the proceedings against them, and therefore no opportunity of being heard. This resolves itself into a question of jurisdiction, and if judgment be rendered by a court having no jurisdiction, or against a person who has no notice to defend his rights, it is no judgment at all. In all proceedings, said Justice Reed of the Supreme Court of North Carolina, it is necessary that the person whose rights are to be affected should, in some way, be a party to the proceedings. It is not sufficient that the court should have jurisdiction of the subject matter, it must also have jurisdiction of the person. It is a clear dictate of justice that no man shall be deprived of his rights of person or property without the privilege of being heard. And it is well settled, that judgment without service of process is void. Section 242, Habeas Corpus pending examination on criminal charge. Where there is good reason to believe that a felony has been committed by a person who is detained on reasonable grounds of suspicion, therefore to await examination before a committing magistrate upon the charge of having been concerned therein, a higher court will not interfere, pending the examination, to release him upon habeas corpus. The preliminary examination of a person charged with a crime, especially a non-bailable offense, must be made promptly, and should not be delayed to suit the mere convenience or personal accommodation of the officers of the law. The prisoner's rights are to be considered and respected, and he is not presumed to be guilty because he is under arrest. The presumption is the other way. Section 243, waiving examination. In the state of Nevada it has been decided that in all cases where a party has been arrested, charged with a crime, and brought before a committing magistrate, an examination should take place, and that the practice of allowing persons so charged to waive an examination is irregular, and should be discontinued. The Supreme Court of that state has also decided that the issuance of a commitment by a justice of the peace, when examination is waived, without the introduction of any testimony, is erroneous, but furnishes no ground for petitioner's discharge upon habeas corpus. Part 3. Inquiries after indictment and before judgment of conviction. Section 244. Reasons why the courts decline to make inquiry into a commitment after indictment found. There is a vast difference between inquiring into a commitment before indictment found and one instituted afterwards. The former we have considered. Let us take a view of the latter. The testimony taken before the grand jury is not written, and they are not to disclose the evidence on which they act. The grand jury find an indictment, and when a court or judge attempts to go beyond the indictment, to the facts on which it was found, how are they to be ascertained? The court cannot entertain the question without receiving precisely the same testimony which the jury would be obliged to receive on the trial. It would thus usurp the province of the jury. In what mode are the courts to be informed of the secrets of the jury room, so as to determine whether the case presented there is or is not a criminal offense? Again, establish the principle that inquiry may extend beyond the indictment, and where will the range of inquiry cease? The commitment may be regular and the detention legal, but the prisoner be innocent. Inquiry after indictment, however, would bring up the question of guilt or innocence to be determined, and that under summary proceedings by habeas corpus. Here the province of the jury is ignored, and every criminal, no matter how complicated the circumstances of his case might be, could, by a plea of not guilty, thus demand a summary trial by the court without jury. There is little difference between inquiring whether a party is innocent and trying his plea of not guilty. The question of guilt or innocence, therefore, should not be tried by the court or judge after indictment and upon habeas corpus, even should not the prisoner be discharged by proving his innocence, however clear the proof may be, but he ought to abide his trial by jury. Section 245. Inquiry may go to whether indictment charges any offense. While inquiry cannot extend beyond an indictment into fields of unknown facts, the indictment itself may be examined upon habeas corpus, although it appears that the defendant has been detained to answer it under a continent in due form. The court, or judge of the court wherein such indictment is pending, may proceed to inquire whether it charges any offense known to the law, for this goes to the jurisdiction, which is always a proper subject of inquiry in a proceeding of this character. If such were not the case, the simple warrant of a court, however arbitrary it might be, would constitute a complete answer to the writ. An indictment must contain the statement of an offense known to the law, and, under the rules well settled by judicial decision, that this may be inquired into. If the court or judge determines that it does not, the prisoner must be discharged as a matter of right, particularly in those states where a statute provides that he shall be discharged when the process, though proper in form, has been issued in a case not allowed by law. Section 246. Defective indictment. Where the court renders such a judgment on the record as the law demands, and, on taking the whole record together, in investigating a proceeding on habeas corpus, and where a defective indictment is the point in controversy, is satisfied that enough appears, although the indictment is clearly defective, and so much so that a demurrer to it would be sustained, to retain the accused in custody until another term of court, it will not discharge the prisoner. A defect in an indictment for an assault with intent to commit murder, consisting in leaving out the name of the person assaulted, and without any averment that the person's name was to the grand jury unknown, is not a sufficient ground upon which to discharge an accused party on habeas corpus invocation, and it is doubtful whether it would be sufficient in term time. The next court where the indictment is found, after the hearing, can either discharge the party or permit the defective indictment to be null prost, and order another one to be preferred, or the first indictment may be amended by consent of the accused. The indictment should, however, at first contain the name of the person assaulted. Section 247. Guilty or not guilty. It is a fundamental error to suppose or assume that an officer granting the writ of habeas corpus has a right to try the question whether a prisoner indicted is guilty or not guilty of the crime of which he is charged. The law of habeas corpus, both common and statutory, never contemplated that such a trial was to be had. As we have said above, the only way in which this question can be tried is by the intervention of a jury before a proper court, and in a capital case a man cannot be tried, even by his own consent, except by a jury of 12 men. The commitment made by an examining magistrate of inferior jurisdiction, such as a justice of the peace or police judge, may not only be reviewed, but the court may hear new proof, and bail or remand the prisoner, as justice may require. While this is true, the court will not discharge one duly committed on a regular indictment, upon proceedings by habeas corpus, as we have said before, although the prisoner may be able to clearly prove his innocence. The rule in this respect seems to be as stringent as where one has been convicted and sentenced to a penitentiary upon perjured testimony. In a hearing before Justice Knox, of the New York Supreme Court, it was asked, suppose a person is indicted for the murder of A, B, and committed, and subsequently A, B, is produced alive, may not that person, on habeas corpus, on producing A, B, alive before the officer, be acquitted and discharged of the offence as on a trial? His Honour answered, no. A trial in court, said he, and an acquittal by a jury, or the entering of a null prosequi by the district attorney, by order of the court in which the indictment is pending, are the only methods by which the prisoner can be fully discharged. It is not necessary to say whether in the case supposed the officer might not properly be led to bail. If, in a given case, it appeared by the indictment that no offence was charged, that is to say, if the act charged as having been committed by the prisoner constituted no offence, as if, for instance, the prisoner was held on an indictment which charged that he had absented himself from the state, and he was guilty of a misdemeanor, there would be nothing to try, and the prisoner might be discharged. But when there is an offence charged, a jury must come. If the officer issuing the writ can try the question which the prisoner asks him to try, and decide it in his favour and acquit, why may not the officer decide it against him and punish? If he can say he is not guilty, why may he not say he is guilty? This inevitably follows from the right to try. And then how would the officer execute his judgment? It would be a novel proceeding where an officer authorized to try and acquit, but not to convict. Such an officer would soon, I apprehend, monopolize all the criminal business of the country, especially when the persons tried were really guilty. Suppose, then, that a prisoner, who is held to answer several indictments from which he thinks he ought to be discharged, asks, how, then, am I ever to be discharged? If the district attorney will not move my trial, and the courts will not discharge me as the statute provides, or on a writ of habeas corpus. Justice Knox, above mentioned, said to such a question in a New York case, 16. To this it may be said that it is not to be supposed that courts, judges, or other officers will not do their duty, but the contrary. The statute provides that, previously to every court, the district attorney shall issue his precept, commanding the sheriff to bring all his prisoners before the court, with all papers and process relating to each, which precept the sheriff must obey. 2 R.S. 4th ed. 309, seconds 23, and then, unless satisfactory cause be shown for detaining him, he may be discharged. I hold, therefore, that the prisoner must be remanded, and be discharged after trial and acquittal, or by the entering of a nolle prosequi by the district attorney, or by order of the court under the sections of the statute already quoted. Section 248. Continuing indictment. When an order of court is made continuing an indictment to a future term of court, it is the prisoner's right to be present, and lie ought to be present. But an order of court continuing an indictment without the prisoner's presence is a mere irregularity, and it is a well-established rule, found all through the books, that irregularity and error cannot be reached by habeas corpus, where the jurisdiction is unquestioned. Wherever a court has complete jurisdiction over the subject matter of the indictment, and the sole and exclusive right and authority to try the same, any rulings or orders of the court stand as the lawful rulings of a court of competent jurisdiction, and should be respected as such by all other courts in collateral proceedings as on habeas corpus. However erroneous or irregular they may be, they cannot be overruled on habeas corpus, which in such cases takes cognizance only of such radical defects of a jurisdictional character as to render the proceedings not merely voidable, but void. Continuing an indictment does not divest the court of its jurisdiction. Section 249. 2 bills of indictment. Death penalty on one, no trial on the other. 2 bills of indictment were found in South Carolina against a prisoner for passing counterfeit bank bills. He demanded his trial on both, but was tried only on one, convicted, and sentenced to be hanged. He was not prosecuted on the second indictment, under the expectation that he would suffer death in consequence of his conviction on the first. He was pardoned, after his conviction, by the governor, and set at liberty. Afterwards he was arrested on the second indictment, and sought relief by habeas corpus. 3 of the judges, a majority of the Constitutional Court of Columbia, were of opinion that the prisoner was entitled to his discharge. The conviction on one indictment did not prevent the state from proceeding on the other. The prisoner demanded his trial in both cases, and he ought to have been tried at the second court, after demanding his trial on both indictments, or discharged as to the indictment not proceeded on. The solicitor and the court should not have calculated on his suffering death on the conviction in the case tried. A new trial might have been granted and the prisoner admitted to bail, or judgment might have been arrested, or, as it happened, there might be a prospect of his being pardoned. The other 2 judges, however, thought it was unnecessary after conviction on one indictment to proceed on the other. The prisoner was pardoned at his own instance, the same as if he had escaped, etc. Motion granted affecting prisoner's discharge. Section 250. Existence of indictment. Its legality. Bench warrant. Upon proceedings by habeas corpus, a court is not authorized to, nor will it, inquire into the question of fact as to whether or not an indictment, regular upon its face, was ever found by the grand jury. This is an informality or irregularity merely which may be corrected by other processes known to the law. Neither will the illegality of a grand jury that found the indictment be considered upon such proceedings. Where the prisoner surrenders himself into the custody of a sheriff on a charge of murder, and is admitted to bail by a county judge, and is thereafter indicted for murder by the grand jury of the proper county, and is arrested and held in custody by the sheriff, under a bench warrant therefore, issued by the county court, he cannot procure his release on habeas corpus. Where the county court has jurisdiction of the person of the defendant and of the indictment, the court is not restrained in the exercise of its jurisdiction, after an indictment has been found against the prisoner, by reason of any proceedings previously had in the matter. If the bail already given is considered to be sufficient security, the court may allow it to stand unchanged, but if not, it has power to order him to give additional bail or go into custody. If the court consider it to be a case in which bail ought not to be taken, it may order him into custody notwithstanding any bail which may have been given before the indictment was found. In the words of Mr. Justice Sanderson, it would be anomalous to hold that the court can, as it undoubtedly may, compel the defendant to come into court by its warrant for the purpose of giving additional bail or going into custody on a bailable offense, and yet cannot compel him to come into court and go into custody on a charge which may not be bailable at all. The court does not exceed its jurisdiction in issuing the bench warrant, and the detention under it is lawful. So again, where the judge of a district court sits as a committing magistrate, and bars admitted a prisoner to bail to appear before the district court, and who has been ordered by that officer, sitting as a district judge, to be confined upon his refusal to furnish a new bond after a true bill of indictment found against him for manslaughter. No proceeding is required to authorize the judge to issue such an order, which is in the nature of a bench warrant. Section 251. Judgment on sufficiency of the indictment. The Habeas Corpus Act of Mississippi provided, that it shall not authorize the discharge out of prison of slaves, after commitment of indictment for any felony. Several slaves were committed upon an indictment charging an offense, or at least, what purported to be one, that of advising and conspiring to make insurrection. They were taken before a circuit judge on a writ of habeas corpus sued out by their owner, and remanded. The case was taken up to the High Court of Errors and Appeals by writ of error to the decision of the circuit judge. Upon the hearing of the writ, the evidence introduced was the record of the indictment referred to, and the proceedings thereupon in the circuit court, by which it appeared that the indictment contained 3 counts, that a demurrer was filed to the whole indictment and sustained, as to the first 2 counts, but overruled as to the third, in which condition the indictment was pending in the circuit court, when the writ was dismissed and the prisoners remanded. Under the statute quoted above, the state insisted that the writ was improperly granted, and should have been dismissed on that ground. On the other hand, it was said that the indictment charged no offense for which the slaves were punishable by indictment, and that, in consequence thereof, the indictment must be regarded as a nullity. Mr. Justice Handy, of the Court of Errors, in delivering the opinion of the court, disposed of the case in this way: it appears that, on demurrer, the indictment had been adjudged good and sufficient by the court in which it is pending, and that the case stood upon that judgment in that court when the writ of habeas corpus was sued out. Until that judgment was set aside or reversed, it was the law of the case, and it was not competent to call it in question upon the writ of habeas corpus, and upon an adverse decision being made thereupon, to bring the question to this court by writ of error to that judgment. For that would be virtually to make the writ of habeas corpus a writ of error to the judgment of the circuit court, and call upon the judge to reverse the judgment upon the demurrer and declare the indictment, then duly pending in the circuit court, insufficient. So the court, upon writ of error to the judgment on the habeas corpus, is required virtually to reverse the judgment on the demurrer, when that judgment is not before us. All this is manifestly irregular, and not to be tolerated. The judgment of the circuit court, holding the indictment sufficient in law, must be taken as correct, until it be reversed, and that can only be done by this court, when it shall be brought before us on writ of error. The evil consequences arising from the course of proceeding, in resorting to the writ of habeas corpus in cases like this, are most obvious. 1. The judgment of the circuit court upon the demurrer, if the writ be sustained, would be reversed without writ of error extending to it. In law it remains in force. What, then, is to be the course of proceeding of the court upon the indictment? It would be to proceed with the cause, treating the indictment as sufficient under the judgment previously pronounced. But the court would find that the prisoners had been taken from the custody of the law, and were not in the power of the court, having been discharged from prison under the writ of habeas corpus. Such a state of case would present a great anomaly. 2. But to determine the indictment to be insufficient, and to discharge the prisoners on habeas corpus on that ground, and without hearing the evidence upon which the charge was founded, would be attended with another serious mischief. In such a case the only question presented would be the sufficiency of the indictment. It might be that the indictment in its form is insufficient, and on that ground that it would be liable to be quashed, and yet there might be sufficient cause upon the facts of the case to keep the prisoners in custody, to be proceeded against upon another indictment, which might be properly framed to meet the offence of which the prisoners were really guilty. And yet, in such a case, and as this case is here presented, the prisoners would be discharged, and might be placed beyond the reach of punishment, simply because the indictment was not technically sufficient to charge them with the offence intended to be charged. If such a course be justifiable upon sound principle, not only the sufficiency of all indictments for capital offences, but the correctness of the decisions of the courts where they are pending, adjudging them to be sufficient, are subject to the determination of a judge at chambers, with power to overrule, in this informal mode of proceeding, the judgment of the proper court duly pronounced, and the same principle would give to a judge sitting on habeas corpus the power to annul the judgment of the circuit court upon final conviction, and this on the ground that the indictment was insufficient, in charging no offence. It is clear that such questions were not intended to be embraced and determined in the proceeding by habeas corpus. We are therefore of opinion, that when there has been an indictment which has been held by the proper court to be good, and which judgment stands in full force, or when the prisoner, without such judgment, claims his discharge on habeas corpus, merely on the ground of the insufficiency of the indictment, without the adduction of the evidence on which the indictment is founded, showing that he should not be held in custody in the matter, in either of such cases, the writ of habeas corpus should not be entertained. It follows from this view, that the writ of habeas corpus was properly dismissed, and the judgment is affirmed. Section 252. Process without warrant of law. A petitioner for a writ of habeas corpus alleged that the relator had, after conviction on the 9th of July, 1881, been sentenced to an imprisonment in the Allegheny County Workhouse, in Pennsylvania, for a term of 3 months, and to pay a fine of $500 and the costs of prosecution, that he had served the term, and was discharged on the 10th of October, that on the same day he was arrested under alleged legal process issued by the clerk of the Quarter Sessions, and was committed to the common jail, where he remained. The writ was allowed and answer made, alleging that the discharge from the workhouse was illegal. On the bearing it appeared that the process under which the relator was arrested commanded his arrest to answer the same indictment upon which he had been tried and convicted. Said Chief Justice Sharswood, "It may be that if the prisoner was illegally discharged from the county workhouse, the Court of Quarter Sessions could have caused him to be rearrested on a bench warrant, and have returned him to the county workhouse in pursuance of the original sentence and of the Act of Assembly cited. But it is very clear that the process by which he was arrested, after his discharge from the workhouse, and imprisoned in the county jail, was without warrant of law. The prisoner must therefore be discharged, without prejudice, however, to the right of the Quarter Sessions to issue a bench warrant, as above indicated." Section 253. Effect of order arresting judgment, etc. When a defendant has been indicted, tried, and found guilty of a felony, it has been held in California that the effect of an order arresting the judgment is to place the defendant, as nearly as other and controlling rules of law will permit, in the same situation in which he was before the indictment was found, and that upon its entry he must be discharged unless he is detained in custody by virtue of some other legal process or order which it is in the power of the court to make. The court may, of its own motion or upon the application of an interested party during the term, in any criminal case, modify or set aside an erroneous order, or, under Section 443 of the Practice Act, arrest the judgment without motion, upon its own view of fatal defects in the indictment upon which such judgment may be rendered. But upon habeas corpus, any errors committed by the court in setting aside or modifying such order or judgment cannot be considered, where the order upon which the party is held in custody is regular upon its face, and one which the court had power to make. Neither will once in jeopardy be reviewed or inquired into on habeas corpus. If pleaded and disregarded, it is an error to be corrected by appeal. An order erroneously granted is not necessarily void. If it were, it would be considered, for the question of jurisdiction would then be open, and the prisoner would be discharged for want of power in the court to act at all. Where the court has jurisdiction of the process and of the subject matter, the inquiry ceases. Section 254. New trial delay in bringing to trial. The fact that a former conviction on an indictment has been reversed and a new trial ordered by a court of review, and on the prisoner's application, leaves matters to stand as if there never had been any trial on the indictment. In the eye of the law, he has not been tried at all, and it is not a violation of the constitutional provision, which declares that no person shall be subject to be twice put in jeopardy for the same offence. And this fact cannot be made a tenable ground for the prisoner's discharge on habeas corpus. Statutory provisions, under which a prisoner is declared to be entitled to his discharge if not brought to trial before the end of the next term of the court, unless satisfactory cause be shown by the district attorney, have been decided not to be a statute of limitations, and that a failure to comply with them is a mere irregularity, and one which forms no sufficient ground for a prisoner's discharge on habeas corpus. Section 255. Discharge of jury in absence of defendant. In a case on proceedings by the writ of habeas corpus, where the existence of the facts stated in the return is not denied, where the validity of the indictment is unquestioned, and where the fact is not disputed that the primary court regularly and lawfully acquired jurisdiction over the person of the accused, who was properly arraigned and put upon trial under the indictment, no inquiry can be had as to whether the relator was in fact present or absent when the jury was discharged from further consideration of the indictment, or whether the decision of the court in discharging them was correct or incorrect. And conceding that the court erred in discharging the jury, and that the alleged error was cognizable in a court of review, it could not be reviewed without the record in the cause was properly before the court of review in such a way as to give it a revisory power under its appellate jurisdiction. But such an error is a mere irregularity, and should not be reviewed under this writ. It does not affect the question of jurisdiction, and where a court has jurisdiction, it is within its power and authority, and is clearly its duty, to entertain, hear, and determine every question that may possibly or legitimately arise during the progress of the trial to final judgment of conviction or acquittal. The fact, therefore, if it be one that the court has improperly discharged the jury in the enforced absence of the prisoner, does not dispossess the court of its jurisdiction over the cause. If so, any further step or proceeding in the action is wholly nugatory, and the only judgment that can be rendered is one of dismissal for want of jurisdiction, instead of a judgment upon the merits, which alone can furnish any protection to the defendant against another prosecution for the same offense. In 1877 Mr. Justice Cornell, of the Supreme Court of Michigan, in a case involving the above principles, quoted the language of the court in Tweed v. Liscombe, whether the determinations of the court upon any or all of the questions were right or wrong did not affect its jurisdiction. In other words, the court had jurisdiction to make wrong as well as right decisions in all the stages of the prosecution, and whether those made were right or wrong cannot be raised on habeas corpus, and said, no final judgment upon the indictment herein has yet been reached, and therefore the district court has never yet been dispossessed of its jurisdiction over it, nor of the person of the accused. In the lawful exercise of this jurisdiction, it has the undoubted authority, under certain circumstances and for certain specified causes, Gen. Stat. C. 116, seconds 16, 17, to discharge the jury prior to a verdict, and to cause a retrial of the indictment before another jury. It necessarily had the right of determining upon the existence of these circumstances and causes, and whether it erred or not, its decision thereon was lawful and valid, until reversed on error. This conclusion is fully supported by the case of Wright v. The State, 5 Indiana 290, which is directly in point on the question under consideration, and we are confident no authority can be found in any way countenancing a contrary doctrine. In that case the jury, having failed to agree upon a verdict prior to the time designated for closing the term, was brought into court and discharged, against the defendant's objection. This was held an improper discharge of the jury, and that, under the laws of that state, it precluded a retrial of the indictment before another jury, yet the court refused to discharge the prisoner on habeas corpus, saying that he must apply for relief to the trial court wherein the indictment was pending. Fully agreeing with the doctrine of that case upon this point, it follows that no inquiry can be had in this proceeding whether the relator was in fact present or absent when the jury was discharged from the further consideration of the indictment, nor whether the decision of the trial court in discharging them was correct or incorrect, and the prisoner must be remanded. Chapter 15, Habeas Corpus as a Quo Warranto. Section 256. Title to office cannot be inquired into on proceedings by habeas corpus, as we have elsewhere said. The writ may sometimes with propriety be used in the nature of a writ of error, yet it will not be converted into a quo warranto to determine a question of usurpation of office. The usual mode of trying such a question is by an information in the nature of a quo warranto. And when the incumbent of an office is exercising its functions, his title to it cannot be tested in a collateral proceeding, but only in a direct proceeding to which he is a party. So it has been held in Pennsylvania that the right of a president judge to exercise his functions within a county attached by the legislature to his district subsequent to his election, cannot be questioned collaterally, that the court will take judicial notice of the legislation by which he claims to exercise his office, so far as to hold him a judge de facto, and as against all but the Commonwealth, a judge de jure, and that the right and powers of a judge de facto, with color of title, can only be inquired into by quo warranto. So a person acting as a police justice de facto, under color of an election in pursuance of an act of the legislature, may rightfully issue his warrant for the arrest of a person, and if the process is regular and legal, the prisoner will be remanded on habeas corpus without an inquiry by the court as to whether the magistrate was a police justice de jure. Section 257. Sentences by officers de facto. Even where a sentence is passed by a de facto judge exercising the judicial office without any real right to do so, it cannot properly be examined on habeas corpus, particularly if he acts under color of office. As, for instance, where sentence was passed by a judge regularly appointed, and who continued to publicly act as such, no other person having been appointed in his stead, and the prisoner sought discharge by habeas corpus, upon the ground that the judge was disqualified under the Constitution, by reason of having taken a seat in the legislature. So the sentence of one by a circuit judge, who exercised his office under an appointment by the governor made without authority of law, was held valid and binding, though another person was entitled to exercise such office. Section 258. Mere usurpers, etc. But while the right of an incumbent to office, acting under color of right, will not be questioned on habeas corpus, though he is not an officer de jure, the act of a mere usurper, in imprisoning one, or doing anything prohibited or forbidden by law, may be inquired into. For there is a clear distinction between a bold, unwarranted assumption of right to exercise the duties of an officer and their exercise under color of right. An arrest by an officer, acting without any pretense of an election or appointment to office, or without any claim of right, would be legal, and a court would immediately discharge the prisoner on habeas corpus. So, where one attempts to usurp or retain an office to which he has no right, he commits a wrongful act, and if he is imprisoned for it, he cannot be released on habeas corpus. Thus, in New York it has been held that the statutes providing that officers refusing to pass over books, papers, etc., to their successors, or in default thereof to be committed, were obviously intended to be applicable, as against officers de facto, only to cases where the title of the relator to the office is clear, and that if the title is not clear, the remedy is by action in the nature of quo warranto. In that state Daniel S. Baker was illegally appointed supervisor, and an election afterwards had at which one Beck was elected his successor. Baker refused to pass over the books and papers to Beck, and was committed therefore. Baker then sued out a habeas corpus. But the court held that Beck's prima facie title was good and sufficient until overcome, that Baker had not even a colorable title, and that he was supervisor de facto, of itself formed no objection to the proceeding against him. However, where one has been committed to prison for default in delivering up books, papers, etc., under such statutes, if the title of the applicant to the office is doubtful, or if it appears that it is contested with color of right, the officer has no jurisdiction to grant such order, and the prisoner may be discharged upon habeas corpus. Chapter 16. Use of certiorari. Part 1. As ancillary to the habeas corpus. Section 259. English law. In England it may be laid down broadly that the writ of certiorari lies for the removal of all causes from inferior courts. The Court of King's Bench exercises a general superintendency over all the courts of inferior criminal jurisdiction, and unless they are invested by statute with absolute judicature, it may remove the proceedings from any of them. This may be done at any stage of the proceeding, but is generally refused after issue joined. This supervisory jurisdiction is exercised under the writ of certiorari, and not that of habeas corpus cum causa, because the habeas corpus only removes the plaint, whereas the certiorari would bring up all the proceedings from the inferior court, and then the superior court is enabled to do that which might be done in the inferior court. A habeas corpus removed the body cum causa, and proceedings were begun anew in the Superior Court, and plaintiff declared de novo, but on certiorari he proceeds on the record as it stands when removed. The record itself is never removed by habeas corpus as it is by certiorari. Besides, a certiorari goes to the judge, but a habeas corpus to the officer. Again, where 11 Tids Pr. Am. Notes, 397. 269. For Zashali v. Baldo, 1 Salk back. A certiorari, a. A certiorari issues, in order to use the record as evidence, then the tenor, if returned, is sufficient, and countervails the plea of nullity record, but when the record itself is to be proceeded upon, the record must be returned. And there is no difference when the proceeding upon the record is to be removed, whether it be before judgment or after, in both cases the record itself must be removed. The effect of a habeas corpus in removal of causes is only to suspend the proceedings of the inferior court, but a certiorari removes the cause. The practice is to issue the writ of certiorari in connection with the writ of habeas corpus, the former to bring up the record, the latter to bring up the body. But while a superior court in the exercise of its revisory jurisdiction may discharge a prisoner held under criminal process, where the commitment is voidable only, or where the grounds of commitment are insufficient, it must have appellate jurisdiction in the given case. It is not sufficient that it has a more extensive jurisdiction, or is of higher dignity. It must have the power of revision in the particular case, the power to correct or reverse the action of the inferior court. Where no such power exists, a court will refuse to act. The errors complained of, or the grounds of commitment, must be brought under review by means of appropriate process, and this is, as we have said, the writ of certiorari used in connection with the writ of habeas corpus. The evidence given before the committing magistrate, in England, upon a criminal charge, is required to be reduced to writing and certified to the court to which the party accused may be recognized or required to appear, and in case of commitment, these depositions or examinations do not accompany their warrant of commitment. The command of the habeas corpus does not extend to them. That only requires a production of the body of the prisoner and a return of the warrant of commitment under which he is held. But courts have been willing to examine the depositions, and to obtain them the writ of certiorari is resorted to, and which is usually issued at the same time with the habeas corpus, directed to the committing magistrate, and requiring him to bring up the examinations or certiorari, but in order that the court may be furnished with the means of judging in what way they should dispose of the prisoner. And upon the habeas corpus and the depositions brought up by the certiorari the case is heard. It is always proper to have the depositions brought up by certiorari, yet where they have been verified by affidavit the court has sometimes allowed them to be read. Section 260. Doctrine in the Federal Courts. As in England, the writ of certiorari has here always been considered, in appropriate cases, as ancillary to that of habeas corpus, and has long been issued by the courts of this country, as a means of rendering their jurisdiction under the latter writ effective. The power of the federal courts to issue this writ is implied in the 14th section of the Judiciary Act of 1789, and section 716 of the United States Revised Statutes. The writ of certiorari has been issued by the United States Supreme Court to a United States Circuit Court to have brought before the first named court the proceedings of the last named court under which the petitioner was restrained of his liberty, together with a writ of habeas corpus to produce the body of the petitioner. These two writs may also be issued by the United States Supreme Court to a district court. They may be issued by the circuit court to a district courts and by both the last named courts to review the action of a United States commissioner or other committing magistrate, who acts under the laws of the United States. The rule as to committing magistrates seems to be that the information, depositions, examinations, etc., taken by and remaining with them in relation to commitments, are brought up on certiorari. 10. The evidence is examined on which the commitment was grounded, and the reviewing court will do that which the magistrate ought to have done. 11. In other words, the proper inquiry is to be limited to ascertaining whether the magistrate had jurisdiction, and did not exceed his jurisdiction, and had before him legal and competent evidence of facts whereon to pass judgment as to the fact of criminality, and did not arbitrarily commit the accused without any legal evidence. It will be noted in this connection that committing magistrates, as such, make no final judgments such as those of a court of record, for we shall have occasion in the next few pages to show how far certiorari and habeas corpus may be used as a writ of error, which, of course, lies to final judgments only. A cause can be removed from a state court without the aid of the certiorari or the habeas corpus. Neither of them is required to remove the cause. They are issued by the clerk, and are intended to bring up the record and other proceedings from the state court, and to notify the state court that the cause has been removed, so that no further proceedings may be had in the state court. The cause is first removed, and then, after it has been removed, the certiorari or the habeas corpus issues for the above-named purposes. Section 261. In the state courts, the writs of habeas corpus and certiorari are often used as ancillary to each other, when necessary to give effect to the supervisory power of the higher judicators, and this procedure has the express sanction of the statute in many of the states. But where the certiorari is not a creature of the legislature, but is given by the Constitution itself, the supervising courts may, under such a grant of power, issue writs of certiorari, though no act of the legislature concerning them has ever been passed. The ordinary use of the certiorari is to review questions of law only, 5, but its scope may be extended by statute so that the facts may be reviewed under it. The power of the superior tribunals to issue the writ of certiorari exists unless the jurisdiction is taken away by express words. It is a discretionary writ, and is often denied where the power to issue it is unquestionable, and where there is apparent error in the proceedings below. It should not be granted where the party has another adequate remedy, nor until the case is finally adjudicated below. It is provided by statute in New York that if it appear from the facts set forth in the petition for a habeas corpus, that the cause, matter, or other offense for which the person is confined or detained is not bailable, the officer to whom such application is made, instead of awarding a habeas corpus, may grant a writ of certiorari, as if the latter writ had been directly applied for by the prisoner. The proceedings upon this writ are then the same as upon a habeas corpus, and the prisoner may be either bailed or discharged, as the court shall determine. But under this statute a superior court cannot, under the ordinary certiorari, command an inferior tribunal before whom a proceeding is pending to fully commit the petitioner for trial with or without bail, or to fully discharge him. 5. Proceedings in a state court by certiorari, to review a decision on a writ of habeas corpus in that court, do not prevent a court of the United States from proceeding on a writ of habeas corpus subsequently issued from the latter court. Part 2 with habeas corpus as a writ of error. Section 262. At common law, it was said that the Court of King's Bench hath a superintendency over all courts of an inferior criminal jurisdiction, and may, by the plenitude of its power, award a certiorari to have any indictment removed and brought before itself, to determine the validity of it, and to quash or affirm it. And the use of certiorari in connection with the writ of habeas corpus, in examining, affirming, or reversing the proceedings and judgments given by inferior judges has been explained in this way: as the certiorari alone removes not the body, so the habeas corpus alone removes not the record itself, but only the prisoner, with the cause of his commitment, and therefore, although upon the habeas corpus, and the return thereof, the court can judge of the sufficiency or insufficiency of the return and commitment, and bail and discharge, or remand the prisoner, as the case appears upon the return, yet they cannot, upon the bare return of the habeas corpus, give any judgment, or proceed upon the record of indictment, order, or judgment, without the record itself be removed by certiorari, but the same stands in the same force it did, though the return should be adjudged insufficient, and the party discharged thereupon of his imprisonment, and the court below may issue new process upon the indictment. The courts generally required the conviction itself to be brought before them before they would look at the defects of a commitment in execution. Where both were defective, the defendants would be discharged. But they would sometimes discharge for a defect in the commitment, as where the certiorari was withdrawn from the defendant in certain cases, but still remained in the Crown, and where the conviction was not produced by the regular method, on the part of the Crown. So the following rule resulted: if the warrant of commitment be bad, and the justices or informer prefer to rely on a good conviction, it is for them to bring up such conviction by certiorari, and that it is not the duty of the defendant to remove a conviction of which he is not supposed to know anything, and which may not exist. If the conviction be not brought before the court will not presume that there is a good one, or any, but will decide on the document actually before them. 6. All the courts, however, could not issue a certiorari. This was so of the Court of Exchequer. So, while their power to issue this writ was not coextensive with their power to issue the writ of habeas corpus, they would, on the hearing of a habeas corpus, admit the record of conviction, although they had no power to compel its production by certiorari. The conviction was produced, verified by affidavit. They have also discharged the prisoner for a defect properly cognizable only on certiorari. 8. The Attorney General's fiat is a prerequisite to the writ of certiorari, and the court, without such fiat, will not direct a certiorari to issue for the purpose of bringing up the record on which to found writ of error, and the general rule is that a writ of habeas corpus will not be granted where the party is in execution on a criminal charge. After judgment, on an indictment according to the course of the common law. Section 263. In the federal courts, the writs of habeas corpus and certiorari seem to be used in the nature of a writ of error to review questions of jurisdiction only. The United States Supreme Court disclaims any general power of review over the judgments of the inferior courts in criminal cases, by the use of habeas corpus or otherwise. While, therefore, it is true, says Mr. Justice Strong, that a writ of habeas corpus cannot generally be made to subserve the purposes of a writ of error, yet when a prisoner is held without any lawful authority, and by an order beyond the jurisdiction of an inferior federal court to make, this court will, in favor of liberty, grant the writ, not to review the whole case, but to examine the authority of the court below to act at all. 2. Section 264. In the state courts, the power of all courts under the writ of certiorari is not coextensive with their power under the writ of habeas corpus, and a very important difference exists between the powers of courts having jurisdiction over both writs and those having power only over the writ of habeas corpus. The former, where both writs have been issued, may, for errors which render the conviction only voidable, reverse or quash the conviction, and discharge or remand the prisoner. The latter can only remand him, and leave him to his remedy by writ of error or certiorari. The action of a committing magistrate or court, on the question of admitting to bail, is the subject of review by an appellate jurisdiction, upon habeas corpus aided by the writ of certiorari, but such action is final as to other magistrates or courts of coordinate or concurrent jurisdiction, where habeas corpus proceedings are had before a judge as an officer, and not as a court. A writ of certiorari to review the proceedings is properly directed to him. A court will not review upon certiorari the judgment of a court committing for a contempt. Where the power to issue the writ of habeas corpus, in certain cases, is denied to designated courts and officers by legislation, the prisoner, upon a refusal of his application, must, in default of appeal, be left to his remedy by certiorari. In Ohio it is held that a proceeding on certiorari to reverse an order made by a state judge discharging a prisoner on habeas corpus is in its nature a civil proceeding, and by the code must be by petition in error and not by certiorari. 3. In Alabama, on original applications for a habeas corpus, sued out under their statutes before a single magistrate, and for the purpose of drawing the validity of a judgment in question, the proceeding is regarded as of an original nature, and that it brings the judgment in question collaterally. Therefore, only illegality will be inquired into, and not errors or irregularities, however gross they may be. But their statutes are not regarded as taking away from the courts the common law power to award a certiorari to remove the record and a habeas corpus to remove the body. So where the validity of a judgment is assailed in this way, the proceeding is considered appellate in its nature, and a full enquiry may be made. Chapter 17. Comity of Courts. $265. General Rules. Where a court of general jurisdiction, and legally competent to determine its own jurisdiction, has acquired prior jurisdiction de facto, over person or subject matter, no other court will interfere with or seek to arrest its action, while the case is still pending and undetermined. This rule is sustained and supported by all the analogies of the law. It is right in principle, and preventive of unpleasant collision between different tribunals. A court should extend to other tribunals the same comity and the same confidence which it claims for itself. This rule was clearly recognized in the celebrated Wisconsin cases, where it was decided that courts had a right to determine their own jurisdiction, and that no court was authorized to take matter out of another whose process had first attached and assume the right of adjudication before the former has had an opportunity to determine the matter for itself. It is improper and unauthorized for one department of the government to deny to the others their appropriate powers and attempt to assume them itself. So where one court has obtained jurisdiction of a case, no other court of concurrent jurisdiction will interfere therewith, and when the jurisdiction of a court is exclusive, the law applies with still greater force, for then no other court will take jurisdiction at all to interfere with or interrupt its proceedings preliminarily. This is peculiarly true of the adjudications of the federal and state courts, and the tribunal to which the jurisdiction first attaches retains it. And it makes no difference whether the tribunal be federal or state, because the attempt to take a case from its jurisdiction would not only be resisted to the uttermost, but would be a subversion of the judicial power, before its final decision is given. Nothing can be more scandalous or barbarous than a contest between two courts for the jurisdiction of a criminal prosecution involving the character, liberty, and property of an accused person. Any court of proper sentiments, says Mr. Justice Hughes, so far from seeking to secure such jurisdiction, would rather avoid it if that could legally be done. Where the federal courts have concurrent jurisdiction with the state courts, they will generally send the case to the latter authorities for prosecution, as the courts of the United States prefer to take that course in all cases of concurrent jurisdiction. Federal courts of coordinate jurisdiction will not interfere with each other, and state tribunals of concurrent jurisdiction follow the same rule, as, for instance, for one court to issue a habeas corpus to admit the prisoner to bail, where the application for bail is pending in another court. Chapter 18, Presumptions. Section 266. Distinction between superior and inferior courts. Before stating the rules relating to presumptions, it will probably be well to advert to a distinction usually drawn between courts. In England, the King's Bench, under the old system, was a superior court, and the Common Pleas and Exchequer were inferior courts as to the King's Bench. In 1874, however, the courts of England were absorbed in the Supreme Court of Judicature, and the reader must be referred to the Judicature Act of 1873 for further information concerning the relative dignity of the English courts. All courts, in the language of Chief Justice Marshall, from which an appeal lies, are inferior courts in relation to the appellate court before which their judgment may be carried. But they are not therefore inferior courts in the technical sense of those words. They apply to courts of a special and limited jurisdiction, which are erected on such principles that their judgments, taken alone, are entirely disregarded, and the proceedings must show their jurisdiction. The circuit, district, and territorial courts of the United States, though of limited jurisdiction, are not inferior courts. Neither are the state courts, in any sense of the word, inferior courts, except in the particular cases in which an appeal lies from their judgment to the Supreme Court of the United States, and in these cases the mode of proceeding is particularly prescribed, and is not by habeas corpus. They are not inferior courts, because they emanate from a different authority, and are the creatures of a distinct government. Another definition, by Mr. Justice Baldwin of the United States Supreme Court in a later case, runs thus: the true line of distinction between courts whose decisions are conclusive if not removed to an appellate court, and those whose proceedings are nullities, if their jurisdiction does not appear on their face, is this: a court which is competent by its constitution to decide on its own jurisdiction, and to exercise it to a final judgment, without setting forth in its proceedings the facts and evidence on which it is rendered, whose record is absolute verity, not to be impugned by averment or proof to the contrary, is of the first description. There can be no judicial inspection behind the judgment save by appellate power. A court which is so constituted that its judgment can be looked through for the facts and evidence which are necessary to sustain it, whose decision is not evidence of itself to show jurisdiction and its lawful exercise, is of the latter description, every requisite for either must appear on the face of their proceedings, or they are nullities. It must be observed that a court may have a limited and subordinate jurisdiction, and still not be an inferior court in the sense that it ought to certify everything precisely. Section 267, Presumptions relating to jurisdiction of superior courts. Superior courts are presumed to act by right, and not by wrong, and their acts and judgments are consequently self-sustaining and conclusive, unless plainly beyond the jurisdiction of the tribunals from whence they emanate. The presumption, however, in favor of the jurisdiction of superior courts necessarily ceases when the proceedings themselves negative the existence of jurisdiction. This is well settled as it regards the jurisdiction over the cause, and would seem to be equally true of their authority over the parties. When, therefore, the record shows expressly or by necessary implication that the court has proceeded without notice to the parties, the judgment will be void, and may be disregarded as such in any collateral proceeding in which it is called in question. The judgments of all courts are void in the absence of jurisdiction, but the jurisdiction of superior courts will be presumed, unless manifestly wanting. One of the leading cases on this subject is that of Peacock v. Bell and Kendall, where the rule is laid down that nothing shall be intended to be out of the jurisdiction of a superior court but that which specially appears to be so, and on the contrary, nothing shall be intended to be within the jurisdiction of an inferior court but that which is so expressly alleged. This is laid down by Mr. Hurd as a well-established and leading rule, but in habeas corpus proceedings in this country it is not applied with uniformity. In Vermont, a justice's court is inferior, but the presumption is in favor of its jurisdiction. We are aware, said the court in Wright v. Hazen, that the decisions in New York, and probably in some of the other states, have required the justice to know the facts, limiting the extent of his jurisdiction, at his peril. But no such rule has ever been applied to courts of general jurisdiction, either in Westminster Hall or in this country, and the jurisdiction of justices of the peace has become so important and extensive, that we incline to believe sound policy requires us to extend the same rule of construction in favor of their jurisdiction, which is done in favor of courts of general jurisdiction. In 1881 this case was cited and approved by the Texas Court of Appeals, in Ex parte Boland. The presumptions of law are there extended in favor of the jurisdiction of justices of the peace the same as are accorded to courts of general jurisdiction, and the same rules, so far as applicable under their statutory provisions, apply in that state to mayors and recorders' courts. They modify Mr. Hurd's rule, as laid down in Peacock v. Bell and Kendall, to read as follows: nothing shall be intended to be out of the jurisdiction of a superior court or a justice's court, except that which specially appears to be so. In Connecticut a justice's court is a court of record, and its decisions stand upon the same grounds and are subject to the same rules as those of the superior courts, or those of general jurisdiction. In Pennsylvania the tendency is to the same effect. In Clark v. McCommon the courts say, it is true that the proceedings of a justice are not technically a record, for the court is not a court of record, but they are in the nature of a record, and being judicial proceedings, they cannot be controverted collaterally, or in a suit grounded on the judgment of the justice. Taking a recognizance is a judicial act, which cannot be questioned except by the authority which takes it, and this principle is necessary to preserve uniformity and certainty in judicial proceedings. In Hazlitt v. Ford, 10 Watts, 101, it is ruled that the validity of a judgment of a justice of the peace cannot be controverted in a collateral proceeding by a stranger to it. In the opinion it is said, the justice is a judge of a court which, deriving its jurisdiction from statutory grants, proceeds in most things according to the substance contained in the forms of the common law, and his docket, as to things adjudicated by him, has the conclusiveness of a record. So in Kaufman v. Hampton, 2 Watts and S. 377, the docket of a justice of the peace is the best evidence to show the cause of action before him, and parallel evidence is inadmissible to contradict or vary it. The proceedings of a justice, as to their conclusiveness, are placed on the same platform as the adjudications of a common law court, and it would be difficult to assign a reason for any distinction between them. The rule is founded in convenience, and is as applicable to one tribunal as the other. The presumption is in favor of the proceedings of the Orphans' Court in the same state, but, like those of all tribunals, they are mere nullities when manifestly beyond the scope of the powers under which they take place. In New York, the Court of Oyer and Terminer has been called one of superior criminal jurisdiction, and the Common Pleas pronounced one of general jurisdiction. The Court of Sessions in the same state seems to be one of superior jurisdiction. The County Court of Bennington, Vermont, was, in an action brought in the state of New York, treated as one of general jurisdiction, and the settled rule of presumption was applied in favor of its powers. So of the Common Pleas of the County of Hampshire. The determination of mayor's courts in Alabama has lately been held, on habeas corpus, to be conclusive, until a superior tribunal, in a direct proceeding, pronounces the determination erroneous. In Iowa, the judgment of the police magistrate, after conviction for an offense within his jurisdiction, has been held to be final and conclusive, until reversed on appeal or writ of error, as final and conclusive as that of a court of general jurisdiction, and it is no more allowable to revise the one than the other by a proceeding on habeas corpus. In his work on constitutional imitations, Mr. Cooley says on this matter, when the question is raised whether the proceedings of a court may not be void for want of jurisdiction, it will sometimes be important to note the grade of the court and the extent of its authority. Some courts are of general jurisdiction, by which is meant that their authority extends to a great variety of matters, while others are only of special and limited jurisdiction, by which it is understood that they have authority extending only to certain specified cases. The want of jurisdiction is equally fatal in the proceedings of each, but different rules prevail in showing it. It is not to be assumed that a court of general jurisdiction has in any case proceeded to adjudge upon matters over which it has no authority, and its jurisdiction is to be presumed, whether there are recitals in its records to show it or not. A record is not commonly suffered to be contradicted by parole evidence. But whenever a fact showing want of jurisdiction in a court of general jurisdiction can be proved without contradicting its recitals, it is allowable to do so, and thus defeat its effect. It will thus be seen that the presumption in favor of the jurisdiction of the court of general jurisdiction is one of fact, and not conclusive. It may be rebutted if it depends upon the existence of certain facts, and the court has passed upon those facts. The determination is conclusive until its judgment has been reversed or set aside, and this rule is as applicable to the judgments of inferior as of superior courts. And the learned judge remarked, there is nothing startling in the application of these well-recognized principles to proceedings by the habeas corpus, in favor of the citizen restrained of his liberty under color of judicial proceedings absolutely void. Section 268. Presumptions of jurisdiction relating to inferior courts to show in full the two differences between courts of superior and those of inferior jurisdiction, made by Mr. Cooley, and adverted to in the preceding section. We will state his rules regarding inferior courts. After referring to the presumptions in favor of courts of general jurisdiction, whether there are recitals in its record to show it or not, he says, on the other hand, no such intendment is made in favor of the judgment of a court of limited jurisdiction, but the recitals contained in the minutes of proceedings must be sufficient to show that the case was one of which the law permitted the court to take cognizance, and that the parties were subjected to its jurisdiction by proper process. And in speaking of disproving jurisdiction by contradicting the record, he says, but in the case of a court of special and limited authority, it is permitted to go still further, and to show a want of jurisdiction even in opposition to the recitals contained in the record. As the jurisdiction of limited and inferior tribunals will not be presumed, and must be shown affirmatively to confer validity on their acts, when the facts necessary to give such a tribunal jurisdiction do not appear on the face of its proceedings, and are not proved and, the whole will be invalid, and may be set aside as a nullity when called in question in the course of a collateral controversy. If, however, jurisdiction depends upon a certain state of facts, which must be passed upon by the inferior courts themselves, and in respect to which the decision of the inferior court has been rendered, it must be held final and conclusive in all collateral inquiries. If there was any evidence whatever on which to base it, notwithstanding it may have erred in its conclusions. These principles have been applied by various state courts in habeas corpus proceedings. A notable and striking instance of this may be found in Carney's case, 6, where the police court of the city and county of San Francisco was declared to be an inferior court of limited jurisdiction, whose powers are conferred, and whose duties and mode of procedure are prescribed, by statute, and to which the rule applies that the evidence of its proceedings must affirmatively show jurisdiction of the person of the defendant, and over the subject matter. A reasonable, sensible, and liberal construction of this rule is given by the Supreme Court of Kansas, on original proceedings in habeas corpus. The jurisdiction of a justice of the peace is inferior and limited, and while it must affirmatively appear upon the whole record from the recitals therein that the justice has jurisdiction to hear and determine the case at issue, as jurisdiction will not be presumed, yet this rule does not apply to each process or order or entry issued or made by him. In brief, it is not necessary in issuing each process to recite all the facts conferring jurisdiction. Another general rule is that the proceedings of courts of general jurisdiction not acting within the scope of their general powers, but in the exercise of a special and statutory authority, stand on the same footing with courts of limited and inferior jurisdiction, and will be invalid, unless the authority on which they are founded has been strictly pursued. But in Maryland it is said that the doctrine that where a special limited jurisdiction, distinct from its general jurisdiction, is conferred by statute on any tribunal, its power to act must appear on the face of the proceedings, does not apply to proceedings in cases of habeas corpus. When, however, the existence of jurisdiction is once shown or admitted, the judgments of superior and inferior tribunals stand on the same footing, and are equally and absolutely conclusive. Chapter 19, False Imprisonment. Section 269. What is an imprisonment? If it be necessary for a person to show that he is imprisoned without just cause, or that he is imprisoned at all, in order to obtain a writ of habeas corpus for his release from custody, it is very essential to know what constitutes an imprisonment, and it is the object and purpose of this chapter to give a brief outline of a few principles of law applicable to the subject. It is not always necessary that a person be actually confined within the silent walls of a jail or prison to be under duress, restraint, or imprisonment. Neither is it necessary for a party to be actually confined to entitle him to a writ of habeas corpus, if he can show that the restraint or detention is without probable cause. Any confinement of the person is an imprisonment. An imprisonment is lawful if it be by process from a court of jurisdiction, or by warrant from a legal officer having authority to commit to prison. Their warrant must be in writing, under the hand and seal of a magistrate, and express the causes of the commitment. This should be done, both for the reason that it is unreasonable to send a prisoner to jail without alleging a crime against him, and that the commitment may be inquired into upon habeas corpus. Section 270. During the suspension of the Habeas Corpus Act in England, the Crown was not authorised to imprison suspected persons without giving any reasons therefor, and a magistrate so granting a warrant of commitment was liable for the consequences, if the detention was illegal. To protect those who could not defend themselves in an action for false imprisonment, under these circumstances, Acts of indemnity were passed during such suspensions. Section 271. Arrests. Mere words will not constitute an arrest. If an officer says, "I arrest you," the party is not under restraint, and if he runs away it is no escape. If an officer touches a party to be arrested, however, and the person instantly runs away, he is under arrest. An arrest made by an officer beyond the limits of his authority is void. Every arrest of a man for a civil cause, not warranted by legal process, is unlawful. It appears there are many authorities to show that if a person be arrested under a process which was irregularly issued, it is a false imprisonment in the party at whose suit it was issued, for it was incumbent on him to take care that the process was regularly issued, but the authorities are generally uniform, that it is not a false imprisonment in an officer to arrest a person under the process of superior courts, although the process were irregularly issued. The arrest of a person under erroneous process is not false imprisonment, for the error is not attributable to mistake in an officer of the court, and not to the party at whose suit it was issued. If an officer, in consequence of a charge, takes a person for one moment in his possession, it is, in point of law, an imprisonment. A tapping on the shoulder, with the words, "You are my prisoner," or a submission into custody on account of a charge, even without an actual touching on the part of the officer, would be an imprisonment. But when nothing more passes than merely the charge where the officer does not take possession of the person, it is not by law a false imprisonment. Section 272. Restraint and detention. Any forcible detention of a man's person or control over his movements is an imprisonment. Justice Baldwin defines imprisonment to be the detention of another against his will, depriving him of the power of locomotion. 10. In ordinary practice, words are sufficient to constitute an imprisonment if they impose a restraint upon the person, and the plaintiff is accordingly restrained, for he is not obliged to incur the risk of personal violence and insult by resisting until actual violence be used. 11. Keeping a person in a house against his will, or his forcible arrest and detention in the street, is an imprisonment. The term false as used in connection with imprisonment means illegal, that is, without regard to the question whether any crime has been committed or a debt due. It is a term often carelessly and inaccurately used, and the exact determination of which is imperfectly understood. It seems that in Wisconsin the state may discharge the parental duty which a parent owes to his child, but which he fails to perform, and that the commitment of the child to an industrial school is not an imprisonment as against parental right in the child. Under their statute, which goes to the total failure of the parent to provide for the child, and which was pronounced not to be invalid on the ground that it invaded any natural rights of parent and child, there was no provision made for service of process upon the parent or guardian. It was held in the Supreme Court of Wisconsin that where the commitment of the child was not made upon a conviction for crime, but simply for misfortune, the parent or guardian was not precluded under the statute from asserting any right to the custody and care of the child, which he might afterward be able and willing to resume and establish by clearing his disability, on which the child's commitment was made, and showing that he is otherwise a proper custodian for the child, he would be entitled thereto, notwithstanding the commitment. We apprehend that a refusal of the school officers to deliver up the child under such circumstances would find its remedy in a writ of habeas corpus. Chief Justice Lord Campbell, of the Court of Queen's Bench, considered that the child under guardianship for nurture is supposed to be unlawfully imprisoned, when unlawfully detained from the custody of the guardian, and when delivered to him the child is supposed to be set at liberty. Judge Robert M. Charlton, of Georgia, gave it as his opinion, that to confine the writ of habeas corpus at common law exclusively to cases of illegal confinement would be destructive of the ends of justice. It would enable a kidnapper to maintain possession of a child of tender years taken by him by fraud or force from the bosom of its family, merely because its want of legal discretion would preclude the idea of its being confined against its will. I apprehend that it is not going too far to say that the interests and welfare of society require, that under peculiar circumstances the fact that the child of tender years is detained improperly from the custody of the person entitled to its possession, is sufficient to ground and maintain the writ of habeas corpus. Section 273. Bail. Required in actions of trava for the recovery of personal property, under the provisions of a statute of Georgia authorizing the owner of personal property to bring such suits, cannot in any legal sense be considered an imprisonment for debt, even where the Constitution of the state prohibited imprisonment for debt. A defendant who has been brought into court and discharged from arrest on a criminal charge, and given bail, is not privileged from arrest on civil process immediately afterwards during the sitting of the court, and before he leaves the courtroom. In the Supreme Court of Georgia it was said, in the language of Lord Chief Justice Campbell, that the cases showed that an acquitted prisoner had no privilege reduundo, and that while remaining as a spectator he had no more privilege than anyone else. This rule, it was said, also applied to a prisoner not acquitted but discharged on bail. A person discharged on bail is not imprisoned or restrained of his liberty in such a way as to entitle him to a writ of habeas corpus, directed to his bail. Justice Yates, of the Supreme Court of Pennsylvania, upon a motion made that a habeas corpus issue to bail, that they might be discharged from their recognizances, because the defendants were in a legal sense under actual confinement and restrained of their liberty, and that their bail might surrender them, said that the legislature, by certain acts, did not contemplate a party admitted to bail as a prisoner under commitment, besides confining the authority and requisition so to act solely to the court before whom the prisoner is to receive his trial. Would not a habeas corpus, directed to the bail of a supposed offender, be perfectly novel? Could we, or either of us, do an act which would amount to a legal discharge of the recognizances in the court of oia and termina? Justice Smith inclined to the same view, but would give no decided opinion. The motion was denied. In cases where the committing magistrate has no authority to take bail, a habeas corpus may issue to the constable or other officer having the defendant in charge. The object of the Habeas Corpus Act was to prevent any wrongful or illegal restraint of personal liberty, and whenever a person is deprived of the privilege of going when and where he pleases, he is restrained of his liberty, and has a right to inquire if that restraint be legal and wrongful, whether it be by a jailer, constable, or private individual. It is not necessary that the degradation of being incarcerated in a prison should be undergone to entitle any citizen who may consider himself unjustly charged with a breach of the laws to a hearing. The whole spirit of the law is in favor of liberty, and if the words were doubtful, they should be construed liberally in favor of that blessing. Chapter 20. Warrants. Part 1. Warrants of arrest. $274. General warrants, in England, have been pronounced illegal, and in the United States are subject to the following constitutional restraint: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Special warrants, however, such as warrants of arrest, warrants of commitment, to answer, etc., deserve special mention of their requisites, as they involve the validity or invalidity of legal process, so far as the warrants themselves may affect it. The validity of such process is often assailed on habeas corpus proceedings, and while the reader must be referred to the authorities contained in works on criminal law, and especially to local statutes, for exact and detailed information, a few general rules will be examined and illustrated. Section 275. The direction. The word warrant, in its primary sense, simply means an authority. It is a written mandate, issued by a proper magistrate, and directed to a proper officer or indifferent person, commanding him to arrest the alleged offender, and bring him before the proper authority to answer for the crime. The warrant ought to be directed to an officer authorized to execute it, and that officer should be the constable at the precinct or county where it is to be executed, because no other constable, and a 40 or no private person, is compelled to execute it. It may also be directed to a particular person by name. In this case, the person mentioned has an authority coextensive with that of him who confers it. It may be directed to a person, not by his name as an individual, but by the description of his official character. It may also be directed to officers, either by their particular names, or by the description of their office, and, in the first case, the officer may execute the warrant anywhere within the jurisdiction of the magistrate who issued it, and in the latter case, not beyond the precincts of his office. Magistrates should be careful to direct their warrants in such a manner that the parties to be affected by them may know that the persons bearing their warrants are authorized to execute them, because, according to the extent of the officer's authority, says Mr. Justice Bailey, his death may be murder, manslaughter, or perhaps justifiable homicide. 8. Though their warrant may be addressed to another, no one but the constable at the place where it is to be executed can be compelled to execute it. A misnomer of the person in the process on which an arrest is made subjects the actors to an action for false imprisonment. Their warrant must contain a command to whom it is directed to make the arrest. A mere authority, license, or permission is not a warrant in law. The direction is an essential part of every warrant, and unless it is directed to the persons above named, it is not a sufficient or proper warrant. The practice of directing warrants to other than officers is not to be encouraged. Where the direction in the body of the warrant runs, say to the sheriff or any constable of the county in which the magistrate resides, an authority to execute the warrant cannot be conferred upon one not an officer, by an endorsement on the back thereof, signed by the justice, 5. Authorizing and empowering such person to arrest the defendant and bring him before the justice. The endorsement is not a direction, and the warrant will not protect the one making an arrest under it. It has been held that a warrant issued by order of the Senate of the United States for the arrest of a witness for contempt in refusing to appear before a committee of the Senate, and addressed only to the Sergeant-at-Arms of the Senate, cannot be served by deputy in the Commonwealth of Massachusetts, and one so arrested was released on habeas corpus. Section 276. Name of the offender. The warrant must name or otherwise describe the person against whom it is issued. The name must not be left in blanks to be filled up afterwards, though it may be inserted before the warrant's delivery to the officer. If the offender's name be unknown, the warrant may be issued against him by the best description the nature of the case will permit of, as the body of a man whose name is unknown, but whose person is well known, and who is employed as the driver of cattle, and wears a badge. Number 573. A warrant, however, leaving a blank for the Christian name of the person to be apprehended, and giving no reason for omitting it, but describing him only as the son of J. S. L., and stating the charge of assault without particularizing the time, place, or any other circumstances of the crime, has been held to be too general and unspecific. A warrant to arrest John Doe or Richard Roe, whose other or true name is unknown, without any further description or means of identification of the offender's name, is void. The arrest of a person by a wrong name cannot be justified, though he was the person intended, unless it be shown that he was known as well by one name as the other. Their warrant must be for the apprehension of some particular person, else it will be void, because the magistrate, and not the officer, is to judge of the ground of suspicion. The arrest of one person cannot be justified under a writ sued out against another. The process on its face must authorize an arrest, or it will be void. For a mere inaccuracy in spelling the name, it still being idem sonans, the court will not interfere. An arrest of a felon may be justified by any person without warrant, whether there be time to obtain one or not, if a felony has in fact been committed by the person arrested. And even when there is only probable cause of suspicion, a private person may, without warrant, at his peril make an arrest. It is perilous, for nothing short of proving the felony will justify the arrest. It is thus seen that, in certain cases, private persons, as well as officers, may arrest felons. The following distinction shows the difference between the powers of peace officers and private persons to arrest offenders. If an innocent person is arrested upon suspicion by a private individual, such individual is excused if a felony was in fact committed and there was reasonable ground to suspect the person arrested. But if no felony was committed by anyone, and a private individual arrest without warrant, such arrest is illegal, though an officer would be justified if he acted upon information from another which he had reason to rely on. 10 Bishop says, for a past offence lower than felony none of these officers, sheriffs, constables, police officers, and the like, can make an arrest without warrant, unless, for example, it is such a dangerous assault as may end in felony by the death of the injured person. Where it is felony or treason, and is past, the distinction between the powers of the officer and the private person is this: should the one arrested be found not to be guilty, the private person will not be justified unless an offence had been committed by someone, while the officer is justified though no offence had been committed, yet both must have had reasonable cause to suspect the one apprehended. The official proclamation by the governor, of the commission of a felony, published as the law directs, is sufficient evidence of the commission of it to justify an arrest of the supposed felon by a peace officer without warrant. If a writ of habeas corpus be obtained where the arrest is upon suspicion, and without a special warrant, proof must be given to show the suspicion to be well founded, or the prisoner will be discharged. Where an officer arrests one for felony on a telegram, without warrant, his duty is the same as if he had made the arrest by warrant. He must take the prisoner, without unnecessary delay, before a proper officer, for the hearing of proof, or to be held, if the circumstances justify it, for further examination. If this is not done with reasonable diligence, the arrested party is entitled to a habeas corpus, to have his detention inquired into. Section 277. Statement of offence in magistrate's warrant. It is a general rule that the offence must be stated with reasonable certainty. This applies to the warrant of arrest issued by the magistrate as well as to the commitment. The legal presumptions of which we have heretofore spoken do not apply to these processes of inferior courts any more than they do to their judgments, which will be treated in subsequent chapters. The South Carolina Court of Appeals have laid down the law very clearly concerning the form and effect of the common magistrate's criminal warrant. It is a great mistake, said Mr. Justice Earle, to suppose that a warrant for apprehension, or a warrant of commitment, need contain any statement at all of the evidence on which it is founded, or need enumerate any of the facts and circumstances accompanying the offence. There are several high authorities that it need not even contain a specification of the particular offence. But the better opinion, as well as the general and approved practice, is, that it should state the offence with convenient certainty, that it should not be for felony generally, but should contain the special nature of the felony, as, for felony of the death of J. S., or burglary, in breaking the house of J. S. In the two cases, heard together, and giving rise to this opinion, the prisoners had been discharged on habeas corpus, and while no decision that could be made by the court would recapture the defendants, and bring them to justice, the Attorney General urged the court to express an opinion which might prevent their former discharge from being urged on their behalf in case they should be retaken, and which might serve to guide magistrates in similar cases. Just precisely how minute a warrant of arrest must be, is a question partly of local usage, and upon which the authorities are not quite harmonious, but it must state for what offence the arrest is to be made, though it need not descend into the particulars of the charge as the indictment does. Before a magistrate can issue his warrant for the apprehension of an offender, probable cause must be shown. This is a reasonable ground of suspicion, supported by circumstances sufficiently strong in themselves to warrant a cautious man in the belief that the person accused is guilty of the offence with which he is charged. But this need not all be detailed in the warrant. The cause named in the warrant must be a good cause, and be stated with certainty. Little weight will be given in legal proceedings to an affidavit made upon information merely. 5. A warrant by a justice to apprehend J. S. to answer such matters as shall be objected against him, ex parte domini regis, without expressing the certainty of the crime, is not regular. The substance of the complaint should be inserted in the body of the warrant, yet if the warrant definitely refers to the complaint on the same paper underscore to the offence described in the annexed complaint, it has been held good. But a warrant issued in North Carolina charging a person with having committed murder somewhere between this place and the state of Texas is void, as being too vague and indefinite. Where statute requires the facts and circumstances to be set forth in the complaint, this must be done, whether the complainant can substantiate them by his oath or not. If he cannot, a subpoena may be issued to compel the attendance of witnesses to testify concerning such facts and circumstances as are thus set forth. Section 278. Statement of offence in warrant of superior judge. The warrant of an inferior magistrate does not differ materially from that of a superior one, except that the presumptions of law in favor of the latter will be more favorable than towards the former. The strictness, however, with which the proceedings of inferior tribunals are scrutinized only applies to the question of jurisdiction, and when the existence of jurisdiction is proved or conceded, the maxim omnia right actu applies to them as well as to courts of general jurisdiction. The mandate or writ of a superior court or superior magistrate, as one of the judges of those courts acting according to the course of the common law, is not to be regarded or examined with the same strictness as the warrant of an ordinary magistrate, or other person acting by special statutory authority and out of the course of the common law. In the case of officers of special or limited jurisdiction, all instruments by which they act, such as warrants to arrest, commitments, orders, convictions, or inquisitions, ought, according to the course of the decisions, to show their authority on the face of them by direct averment or reasonable intendment, but not so with the process of superior courts acting by the authority of the common law. It will be presumed that writs issued by superior courts are duly issued and in a case in which they have jurisdiction, unless the contrary appears on the face of them. A failure to set forth the cause of arrest would be fatal in a warrant issued by an inferior court, but this omission will not invalidate the warrant issued by a superior court. In such a case, Lord Coke says, if it express no cause at all, it will be legal. Section 279. Oath, jurat, and seal. At the earlier common law a justice of the peace could issue his warrant and commit without oath, though Lord Holt said he is not wise if he doth so, for then he must make out the cause of commitment at his peril, but if oath be made, he is safe. 1. The recent doctrine of the King's Bench, however, is that a magistrate has no power to issue a warrant of arrest without oath. And most of the constitutions and statutes of this country have settled the question, that warrants for arrest shall issue only on probable cause supported by oath. The usual and only proper evidence of the oath is the magistrate's certificate, and this, to the complaint as taken and sworn before me, is sufficient, or any other like form from which this idea can be collected is sufficient. If the jurat be inadequate in form, while the facts are sufficient, it may be amended. Their warrant must, of course, be signed by the officer issuing it, or it will be void upon its face. But whether it should be sealed or not is an unsettled question. Chitty says, it is generally laid down, that the warrant ought to be under the hand and seal of the justice who makes it and but it seems sufficient if it be in writing and signed by him, unless a seal is expressly required by particular act of Parliament. In this country where statute prescribes a seal, it must be followed, but where no such requisite is prescribed, it is unnecessary. 10 But there are several respectable authorities to the effect that a seal is essential to a warrant issued by a magistrate to arrest a person for a criminal offence, and that if there be no seal the warrant is void. The term warrant implies a seal in cases where a seal has not been dispensed with by statute. Whether there be a seal or not is a mixed question of law and fact, to be decided by the court and not by the jury. Part 2 Warrants to answer. Section 280. Commitment for treason. At common law it was held that a commitment for treason ought to express the species of treason, else the commitment would be so ill as to entitle the prisoner to bail. Yet a commitment generally for high treason was pronounced good though the commitment failed to express the overt act. Lord Coke put the case of treason contra personam regis, and admitted that to be sufficient. So in the case of a commitment for treasonable practices it is not necessary to express in the warrant of commitment the particular species of treasonable practices. Section 281. Cause and certainty. The mittimus must state for what offence the commitment is made. The minuteness of this, however, is not well determined, and depends somewhat upon local usage. It ought to be stated with certainty, in order that the court may determine whether it be lawful or not. Thus a commitment by the Mayor of London, for divers causes well known to the Mayor, was held not good for want of cause. Their warrant of commitment is sufficient if the corpus delicti be shown. It need not have the precision of an indictment, nor is it necessary to state in it that the act was feloniously committed. But it ought to specify the species of felony, as for felony of the death of J.S., or for burglary in breaking the house of J.S. 10. The charge that the prisoner passed a counterfeit note, knowing it to be such, sufficiently sets forth an offence. 11. In California a commitment by a justice of the peace holding a party to appear before a grand jury to answer upon a charge of murder must state the name of the person alleged to have been murdered. But the omission of such name will not entitle the prisoner to his discharge on habeas corpus. If a statement of facts constituting the offence be made, though it is not a statement of the offences described in the legislative act, habeas corpus cannot relieve. A debtor was committed in Pennsylvania for fraud in making a contract. The commitment was held sufficient on habeas corpus that recited the allegations of the affidavit, the arrest and hearing of the parties, and set forth that, after hearing, the judge was satisfied that the demand of the plaintiff was on contract, and that the allegations were substantiated, in that the said defendant had assigned and disposed of his property with the intent to defraud his creditors, and that he fraudulently contracted the debt respecting which the suit was brought. 8. A warrant setting out the character in which the prisoner is committed in the disjunctive is not good. A warrant need not set forth the authority under which it is granted. A commitment for embezzlement is sufficient if it shows a sufficient offence to warrant the commitment, though it does not state the act to have been done feloniously, on with the precision of an indictment. A warrant of commitment without any date is bad. A warrant of commitment is not evidence of the facts which it recites. A warrant of commitment stated that H.B., in a certain affidavit, made and sworn to by him before C., a competent authority by law to administer the same, did falsely, wickedly, wilfully, and corruptly commit wilful and corrupt perjury. This was held bad, because it did not state that the perjury was committed in the course of a judicial proceeding. In California, a notary public has jurisdiction to administer an oath to the party acknowledging the execution of a deed for the purpose of identifying him. This is a judicial act, and as the testimony of the petitioner given on oath was material to the proceeding and shown to be false, there was, the Supreme Court said, probable cause for holding him to answer upon the charge of perjury, and they dismissed the habeas corpus. A commitment issued without any previous examination is erroneous, but the prisoner cannot take advantage of it on habeas corpus. While it is not necessary, unless statutory provisions require it, to recite in a warrant of commitment the facts on which the charge is predicated, we apprehend the better practice to be to state the time when the offence was committed, or the place of its commission, and also the name of the person injured. At least, enough particulars should be given to enable a court on the return to a writ of habeas corpus to determine what particular crime is charged against the prisoner. If the commitment be good in substance, it will be sustained on habeas corpus, though it contain more than is necessary to be stated therein. The unnecessary matter will be regarded as surplusage. Section 282. Orders and Commitments by Superior Court. Chief Justice Holt said, when a prisoner is in court he may be committed by the court without any process, but if not, process must go. 5. When the prisoner is committed in court to the proper officer there present, there is no warrant of commitment, but the sheriff or other officer is nevertheless obliged to take notice of all commitments in court, and the order in court is his authority. The principle that a court of record may commit without a formal warrant is recognized and followed in this country. A bench warrant and a warrant of commitment, after indictment found, are sufficient, if they recite the fact of indictment and describe the offence generally, though more particularly may be required even by statute before indictment found. Section 283. The direction and conclusion. The commitment must be directed both to a proper officer and to the keeper of a lawful place of imprisonment, commanding the officer to carry and deliver, and the keeper to receive and safely keep, the body of the accused during the time specified therein, or until he is released by due course of law. But one will not be released on habeas corpus because he was committed to the jailer instead of the sheriff, to whom, in strictness, it ought to be made, for the jailer is an officer known to the law, and his custody is the sheriff's to many purposes. The commitment, however, is not good if not directed to the sheriff, unless the person to whom it is directed is in some way the servant of the sheriff. In a habeas corpus proceeding in Iowa it has been decided that the warrant of commitment, if issued to the sheriff of the county in which the examination is held, will authorize his detention and custody by the sheriff of the next most convenient county having a jail. Section 284. Signature and seal. The justice ought to sign the commitment or mittimus in his official character. This is ordinarily done, but it is not now absolutely essential to subscribe himself as Justice of the Peace. 6. Though at common law the mittimus had to be in writing, under the hand and seal of the person by whom it was made, and expressing his office or authority, and the time and place at which it was made, the official character of the person issuing the warrant may be proved alloned. Where the distinction between sealed and unsealed instruments has been abolished by statute, their warrant of commitment need have no seal, but in the absence of any statutory provision on the subject, the omission of a seal will render the warrant void, and the prisoner detained by virtue of it may be discharged on habeas corpus. In Canada it was held that a warrant of commitment under the statute of 31 Vic. c. 16, signed by one qualified justice of the peace and by an alderman who had not taken the necessary oath, was invalid to uphold the detention of a prisoner confined under it, though it might be a justification to a person acting under it on inaction against him. Section 285. What face of warrant should show whether the authority to commit should appear in a warrant of commitment is not definitely settled. We have seen that our constitutions and statutes generally require the charge to be supported by an oath or affirmation before a warrant of arrest can issue. This oath or affirmation would then become essential to the jurisdiction of the magistrate, and where the examining tribunal of the magistrate is deemed inferior, the rule will doubtless require all facts essential to jurisdiction to expressly appear in the proceedings of these courts of inferior jurisdiction. Consequently, where these tribunals are so regarded, their warrant of commitment ought to show on its face that the charge is supported by oath or affirmation. But in those states where this jurisdiction is not deemed inferior, their warrant of commitment, perhaps, need not show an authority to commit, as the courts will not intend a want of authority in the person who issued the warrant, but, until the contrary appear, will presume that he had an authority. And while it is usual and best to state the authority, if it is not done, the justice's authority may be supplied by parole evidence. Part 3. Review by habeas corpus. Section 286. Their warrant of arrest may be impeached, for any radical defect contained in it, by habeas corpus. But its legality should be thus tested before final judgment, because, conceding the arrest to be illegal, the court obtains full jurisdiction of the person of the defendant after he has pleaded to the merits, and this first process then becomes immaterial. In California it has been held on habeas corpus that it is too late to raise an objection to an affidavit or warrant of arrest, after examination and commitment, particularly where there is probable cause to suppose that a felony has been committed. If the officer issuing the warrant had jurisdiction of the process, and received evidence deemed by him sufficient, this evidence will not be weighed on habeas corpus to determine its sufficiency. If the warrant of commitment is prima facie sufficient to justify the imprisonment, and the court finds, on looking beyond the warrant to the affidavit upon which it was issued, that there was at least colorable proof before the officer issuing the warrant of arrest, upon which his discretion might be exercised, it will go no further on habeas corpus, and if this appears, the prisoner cannot be discharged. Where it is competent for the legislature to provide by law that on a charge of a crime or misdemeanor the process may be by summons instead of arrest, it is necessary that the summons contain a full and direct statement of the offense charged, and specify a time when, a place where, and the tribunal before which he is to appear and answer. Section 287. Their warrant of commitment may also be examined into on this writ for irregularities. Indeed, it has been said that there is nothing properly before the court upon the return of a habeas corpus, except the warrant on which the relator is imprisoned. On the return to a writ of habeas corpus, issued to inquire into the cause of detention, after commitment by a magistrate, and before indictment, additional proof may be received by the judge for the purpose of enabling him to decide upon the legality of the detention. In California it is held that whether or not the order holding the prisoner to answer on a criminal charge is erroneous, or irregularly entered, cannot be considered one habeas corpus proceedings. Defects mentioned in the two preceding parts of this chapter can no doubt be inquired into on this writ, and if they are found to be so defective as to render the process void, the accused will be entitled to his discharge. But as we have elsewhere treated of what may be inquired into on habeas corpus, the reader is referred to other portions of this work for further, more detailed, and specific information on this question. Chapter 21. Power of courts at the hearing. P. Part 1. May recommit it warrant is defective. Section 288. Practice in the English courts. The prisoner will not always be absolutely discharged, though the warrant of commitment under which he is held be defective, or even void if the court is satisfied from the depositions that an offence has been committed. If the warrant is materially defective, the practice is to discharge from the defective commitment, and commit the prisoner de novo. The writ of certiorari may be awarded to remove the examination and depositions upon which the commitment was founded in the inferior court, to the superior or revisory court, in order that this court may take into consideration the proofs, and either bail, remand, or discharge the prisoner as justice may require. The writ of habeas corpus accompanied by the writ of certiorari seems to be in the nature of a writ of error to enable the Court of King's Bench to determine whether the imprisonment be legal or not. This court had general, original, and appellate jurisdiction in all criminal matters, and it was through these two writs that they acquired possession of the examination and depositions upon which the commitment was founded. It was often conceded that if the case stood upon the commitment alone, the prisoner would be entitled to his discharge, but this procedure, by habeas corpus and certiorari, was intended to help out a defective commitment, and, however irregular it might be, if the court discovered in the depositions sufficient evidence of any offence to justify the detention of the prisoner and put him upon his trial, he would not be discharged, but remanded in general terms. But it will be perceived that this left the prisoner free to sue out another writ of habeas corpus upon the same original defective commitment, and in 1802, at the time of the decision in King v. Marks, it occurred to the officers of the Crown Office to suggest an alteration of the practice in this respect, founded upon the consideration that prisoners thus remanded might renew the same application to another court or judge. So the rule in that case was changed to a discharge from the prisoner's confinement by virtue of the warrant mentioned in the return, and to a recommitment for the offence shown in the information, etc. But it must be distinctly understood, that if the court granting the habeas corpus does not have the power of a committing magistrate over the offence shown in the depositions, it must discharge the prisoner if the commitment cannot be sustained. Thus where the Convention Act of 6 and 7 Vic. c. 75, vested in certain officers the power to arrest and deliver up fugitives from justice from France, the Court of Queen's Bench refused to look into the depositions referred to by their warrant, and remand the prisoner on their own authority, for they had none of the kind in such a case, although they pronounced the warrant insufficient for the prisoner's detention. So they discharged him. The warrant by virtue of which a dangerous lunatic is held in custody may be insufficient, but the court will not discharge him as a matter of course, because the order of confinement does not fulfill the requirements of the statute under which the detention is claimed. In such a case, in answer to an argument that the court must necessarily, however inconvenient, allow the lunatic his common law liberty, Lord Denman replied, if the court thought that a party unlawfully received or detained was a lunatic, we should be betraying the common duties of members of society if we directed a discharge. But we have no power to set aside the order, only to discharge. And should we, as judges or individuals, be justified in setting such a party at large? It is answered that there may be a fresh custody. But why so? Is it not better, if she be dangerous, that she should remain in custody till the Great Seal or the Commissioners' Act? Therefore being satisfied, in my own mind, that there would be danger in setting her at large, I am bound by the most general principles to abstain from so doing, and I should be abusing the name of liberty if I were to take off a restraint for which those who are most interested in the party ought to be most thankful. 1. The Statute of 31 Car. 2. Prohibited the King's Bench from letting to bail when the commitment was for felony or treason plainly expressed in the warrant of commitment, while at common law they could let to bail in such cases, and also examine the grounds of commitment and discharge the prisoner altogether, if it was evident that he had committed no crime, or if the depositions disclosed the fact that he had committed a different crime from the one mentioned in the warrant of commitment, they had the power to remand him for that, or commit him de novo for it. The King's Bench had unlimited power to bail at common law, and to issue the habeas corpus in all proper cases, and to absolutely discharge. And this was independent of the Statute of 31 Car. 2. But on a habeas corpus sued out under this statute, the prisoner could procure his liberty absolutely where he had not been indicted and tried the second term after his commitment, or where he had been tried and acquitted. In all other cases, he was required to be remanded or let to bail. That the King's Bench, in the exercise of its common law jurisdiction, as the Court of Supreme Criminal Judicature, had more comprehensive powers under the writ of habeas corpus than were conferred by the Act of 31 Car. 2. On the officers named in it, is apparent. Section 289. Illustrations of the general rule will be found in the case of the King v. Judd, where it did not sufficiently appear to the court, from the commitment, that a felony had been committed. The court, however, were satisfied from the depositions that some offence had been committed by the prisoner, and they refused to discharge him, but admitted him to bail. In Rex v. Marks, will be found another where the prisoner was recommitted for an offence disclosed by the depositions, having been discharged from the defective commitment. In this case, two of the justices expressed themselves as follows: Grouse, J. There is no doubt of the power of this court, King's Bench, to bail, if they see occasion, in all cases of felony, even in case of murder, though there should be no doubt as to the validity of the warrant of commitment. On the other hand, there is as little doubt as to their power of remanding, notwithstanding the warrant of commitment be defective, and it is the constant practice of this court to remand prisoners in such cases, if it appear on reading the depositions that there is a fair ground to authorize them. LeBlanc, J. This court have clearly a right to bail the parties accused in all cases of felony, if they see occasion, wherever there is any doubt either on the law or the fact of the case. And it is equally clear that though the warrant of commitment be informal, yet if upon the depositions returned the court see that a felony has been committed, and that there is a reasonable ground of charge against the prisoners, they will not bail but remand them. The same rule applies with respect both to the law and the fact. Unless we see reason to doubt the truth of the fact charged, the prisoners must be remanded, and the same consequence follows, unless we see reason to doubt whether the fact charged constitutes any offence within the law. Section 290. The practice in our courts has conformed to that in Rex v. Marks, cited in the two preceding sections. In some of the states the testimony of witnesses in criminal examinations is not reduced to writing, and when a superior court is passing upon the validity of a warrant of commitment upon a proceeding by habeas corpus, the prisoner must be either remanded or discharged, as the court shall determine the sufficiency or insufficiency of the warrant upon its face. But even here the helping hand of the statute may intervene and give the court power to proceed and hear the case de novo when the warrant of commitment is fatally defective. In these states there are strong reasons why the commitment should show the facts constituting the offence, as there are no depositions to show upon what evidence the commitment is founded, because everything conducive to a full and fair hearing should be before the court, in order that it may determine whether the imprisonment is unlawful or not. Otherwise the powers of the court may be seriously restrained. The general rule is, that an invalid warrant will justify the discharge of the prisoner, but this rule is not inflexible. Even where there is no statute to direct the action of the court or judge under the writ of habeas corpus. It is believed, however, that in a majority of the states some provision is made to have the evidence upon which the committing magistrate acted certified up, or otherwise properly presented to the court or officer hearing the habeas corpus. Under this state of law, then, the rule is that if the commitment is found to be informal or insufficient, upon the hearing of the writ, the court will discharge the prisoner from that commitment, and recommit him in proper form, if there be sufficient cause. The prisoner may be guilty of a different crime from that specified in their warrant. If so, it is the duty of the court to commit him for trial for the offence of which he appears to be guilty. In California, upon a hearing on habeas corpus, if the offence be so defectively set forth in the warrant of commitment that the party cannot be held under it, and it appears from the papers that he should not be discharged, the court will hold him for examination, and cause the witnesses to be subpoenaed for such purpose. Same rule in Indiana. With reference to a second commitment by a justice of the peace, Mr. Justice Field, when on the Supreme Bench of California, said, "There is no doubt that where an examination has been had by a magistrate, and a commitment has been issued by him which is defective in form or substance, a second commitment, omitting or correcting the defects of the first, may be issued, provided there be any order, or judgment, or entry of the magistrate, made at the conclusion of the examination, to which reference can be had to guide him in the matter. He cannot resort merely to his own recollection for the facts of the case. The statute contemplates that his order, either of discharge or committal, made upon the completion of the examination, shall be reduced to writing. The court, sitting as a court, possesses the power to commit one charged with an offence. On this point we have the following opinion of Chief Justice Marshall: "It is believed to be a correct position that the power to commit for offences of which it has cognizance is exercised by every court of criminal jurisdiction, and that courts as well as individual magistrates are conservators of the peace. Were it otherwise, the consequence would only be that it would become the duty of the judge to descend from the bench, and in his character as an individual magistrate to do that which the court is asked to do. This principle was acted upon in a late case in the state of Nevada, where the Supreme Court were clearly of opinion that if they found the prisoner guilty of another offense than that stated in the warrant of commitment, they had, under the Habeas Corpus Act, power to issue a new commitment. If the court or judge does not order a recommitment on his own motion, after the warrant of commitment has been adjudged void on habeas corpus, the prosecutor should make a motion for a new commitment, if one is sought, because the papers on which the first warrant is founded are functus officio. Section 291. Illustrations. In Colorado, where an indictment contained 2 counts, and a null prosequi was entered as to one, and the other quashed, the indictment, as such, was held to be functus officio, and although the petitioner could no longer be called upon to plead to it as an indictment, it nevertheless remained as a sworn accusation against the petitioner, affording prima facie evidence of probable guilt, upon which the district court was warranted in remanding him to answer a new indictment formally drawn and more specifically describing the particular crimes charged. Even where the prisoner is acquitted, said the court, for a flaw in the indictment, he may be remanded to be tried at the next term on a new indictment. In the case of Gordon v. The State, 35 Alabama 432, the court says, independent of statute, the circuit courts possess the undoubted power, where the judgment in a criminal case is arrested, and a null prosequi is entered by the state, to bind the defendant over to appear at the circuit court of the proper county to answer a new indictment for the same offense. Bishop, in the first volume of his Criminal Procedure, says, if an indictment is pronounced bad, the judge is not necessarily obliged to let the defendant go, but he may commit him, or hold him to bail to answer to a fresh indictment, or he may order the officer to take the prisoner before a justice of the peace to be proceeded against on fresh complaint. In California, where the defendant was committed on fatally defective warrants of commitment for rape and grand larceny, and it being evident that he should not be absolutely discharged, he was held for examination. Where the prisoner is held under a warrant for embezzlement, and upon further testimony heard on habeas corpus, a district judge commits him for obtaining money under false pretenses, the order of the judge does not, ipso facto, discharge the petitioner from further custody under the warrant for embezzlement, and he may be discharged on habeas corpus by another from the warrant for obtaining money on false pretenses, and remanded upon the warrant for embezzlement. If a party is brought before a circuit court of one county on habeas corpus to be discharged from illegal arrest, and it appears the imputed offense was committed in another county, he may be recognized to appear before the court having jurisdiction of the offense. A warrant of commitment is irregular in not stating or showing on its face that the justice issuing it had determined that there was probable cause to believe the prisoner guilty of the offense with which he stood charged. This is all that another court examining the depositions or evidence before the committing magistrate will inquire into on habeas corpus, for the purpose of determining whether an offense has been committed. In a Pennsylvania Cyprius court it has been ruled that unless it clearly appears that a prisoner brought up on habeas corpus is entirely innocent, the judge is bound to bail or remand. But, in the language of Justice Gibson, difficulty or hesitation as to the law, arising upon facts indisputably established, is not that kind of doubt of guilt which justifies in refusing to discharge. Where the mind inclines, after full consideration, to pronounce in favor of innocence, it holds only as to doubt of the truth of the facts in evidence, with respect to which the Commonwealth as well as the prisoner has a right to go before a grand jury, who are the constitutional judges in that particular case. But as to refusing to decide necessary questions of law, I have no discretion. Part 2. May discharge or let to bail or warrant be perfect. Section 292. Practice at common law. We have already treated of the incontrovertibility of the return at common law, and shown that the general rule was that neither at common law nor under the Habeas Corpus Act of 31 Car. 2. Could it be controverted with a view to the absolute discharge of the prisoner. With a view to bail, however, extrinsic evidence was sometimes received, sometimes rejected. So when the courts were looking at a warrant of commitment to see what disposition they would make of the prisoner, they examined only the depositions taken before the committing magistrate. In one instance, where a felony was positively charged, they refused to bail, although 8 affidavits of credible persons, proving the relator to be at another place at the time of the robbery, were read. This, it will be seen, would have been controverting the truth of the return, which was not allowable. In another instance the court refused to examine a man brought before them, by admitting extrinsic evidence, to see whether he had been previously acquitted of a charge precisely similar. Again, the defendant was charged with receiving stolen goods, knowing that they were stolen. His affidavit that he did not know they were stolen was rejected. In the 2 latter cases the reason for rejecting the extrinsic evidence must have been the same as in the case of Rex v. Greenwood, but the court may act upon the evidence before them, as shown by the depositions and proceedings before the committing magistrate, and even though the commitment be regular, the court will examine the proceedings, and if the evidence appear altogether insufficient, will admit to bail. For the court will rather look to the depositions which contain the evidence than to the commitment, in which the justice may have come to a false conclusion. Section 293. The practice in the United States is to absolutely discharge the prisoner in those states where the inquiry is not limited to the commitment, and where a full hearing is had upon the facts of the case, if the evidence is insufficient to sustain any charge against the prisoner. When the court or judge thus summarily determines the facts of the case, by hearing testimony, arguments, etc., it is, said Chief Justice Marshall, unimportant whether the commitment is regular or irregular in point of form, and the court having gone into an examination of the evidence on which the commitment is grounded, they will proceed to do that which the court below ought to have done. But of course in those states where the return cannot be controverted, no evidence extraneous to the depositions and informations taken by the magistrate ought to be admitted to controvert the facts contained in those depositions, or the charge exhibited in the warrant of commitment, because to allow this to be done would be to allow the return to be controverted in opposition to the doctrine of the common law. In California, if a party who has been held to answer upon a criminal charge is not indicted by the grand jury at the term of court next after his commitment, he is entitled to be discharged, unless good cause be shown for his further detention. In New York, if a judge, upon a habeas corpus, decides that the prisoner committed to jail under any process is not entitled to a discharge, he must remand him to the custody whence he was taken. He has no power to declare the prisoner entitled to the liberties of the jail, and has no power to remand him conditionally, as, that he be remanded, etc., unless he give good and sufficient bail, to be approved by the sheriff, for the liberties of the jail. Chapter 22. Assailing Judgments of Summary Convictions by Habeas Corpus. Section 294. Definition and History. The judgments of justices of the peace upon offenders for minor and statutory police offences are called summary convictions. There is no intervention of a jury, and as Mr. Justice Blackstone says, the party is acquitted or condemned by the suffrage of such person only as the statute has appointed for his judge. Such offences as common swearing, drunkenness, vagrancy, idleness, and a vast number of others that will be found enumerated in various statutes, come within this summary jurisdiction conferred upon these officers. In England the various offences falling under the heads of idle, vagrant, and disorderly persons, and made subject to this summary jurisdiction, are defined and classified, and the punishments prescribed by the following statutes. The punishment prescribed in those acts is imprisonment and hard labour. This is not a new innovation on the jurisprudence of England, notwithstanding the provision in the Magna Carta of King John, and in that of 9 Hen. 3, c. 29, which declares that no freeman shall be taken, imprisoned, or condemned, but by lawful judgment of his peers, or by the law of the land. It has been the constant course of legislation in that kingdom for centuries past to confer summary jurisdiction upon justices of the peace for the trial and conviction of parties for minor and statutory police offences, and this jurisdiction has been largely increased and extended in modern times, as will be seen by referring to the following works. Workhouses and houses of correction, principally occupied by parties convicted by justices of the peace, have been maintained, certainly from the days of Queen Elizabeth to the present, as parts of the police system of that country, and both the jurisdiction and the means of punishment are deemed essential to the good government and well-being of society. And it is not less so here. Such establishments have been maintained for the same purpose in some states of the American Union. This summary jurisdiction, however, is a creature of statutory birth entirely, and is unknown to the common law of England. Section 295. Constitutionality of these statutes. It appears that in England these statutes under which powers of summary conviction were given to justices of the peace, have never been supposed to be in violation of any right of the subject. At least, we have found no cases intimating such a doctrine. In this country the question has been raised, and so far as we have examined the matter, they have been expressly held to be constitutional. The declaration in the various constitutions, and declarations of rights that a party is entitled to a speedy trial by an impartial jury, is understood to refer to such crimes and accusations as have, by the regular course of the law and the established modes of procedure, been the subject of jury trial, and does not embrace every species of accusation involving either criminal or penal consequences. If the state has no power to provide by law for the summary trial and conviction of vagrant and disorderly persons by justices of the peace, it would clearly follow that no such power could be granted to be exercised under charters or ordinances of municipal corporations, and the consequence would be that, for the violation of all mere police ordinances, prescribing penalties for their infraction, it would be the right of the party accused to insist upon indictment and trial by a jury. Such a mode of proceeding, if it were practicable, has never been contended for, nor could such contention be maintained for a moment. It is regarded as but a part of the police, as contradistinguished from the regular judiciary, powers of the state, a distinction which has from time immemorial been observed between the two, both in England and in the United States. In New York it is said they are rather of the nature of public regulations to prevent crime and public charges and burdens, than of the nature of ordinary criminal laws prohibiting and punishing an act or acts as a crime or crimes. Section 296. How these statutes are to be construed. One would naturally suppose, from reading the language concerning the general nature and requisites of summary convictions as stated by Burns in his Burns Justice, 5 and by the Circuit Judge of New York in the case of the People v. Phillips, with 50 or more authorities, that it would be next to impossible for an unlettered or unlearned justice of the peace to make a valid commitment. In fact, both in England and America these statutes authorizing summary conviction were looked upon as being in derogation of the common law, and formerly great strictness was exercised, not only in construing the law, but in canvassing the proceedings. In speaking of the former and present rules of the construction of summary proceedings before justices of the peace, and how the superior courts were formerly inclined to be astute in discovering defects in convictions by justices of the peace, in the exercise of this summary jurisdiction, Mr. Chitty says, but these absurdities, the indulgence of which might induce a suspicion that the superior courts were formerly jealous of those inferior jurisdictions, have for some time been abandoned, and now the doctrine is, that whether it was expedient that those jurisdictions should have been erected, was a matter for the consideration of the legislature, but that as long as they exist, the courts ought to go all reasonable lengths to support the decisions of the justices, especially as in whatever light they were formerly seen, the country are now convinced that in general they derive considerable advantage from the exercise of the powers delegated to justices, and therefore in modern times they have received proper support from the courts of law, and for the same reason the courts hold that although in drawing up convictions magistrates cannot set all forms at naught (2) yet, on the other hand, they ought not to be entangled in greater forms or ceremonies than the superior courts, and in one of the latest decisions upon the subject it was established that the same, and not a stricter, rule of evidence is to be observed before justices as in the superior courts. For while these statutes are in themselves strictly construed, whatever may have been the former doctrine of construction as applied to commitments in execution by magistrates or tribunals of special and limited jurisdiction, The doctrine seems now to be perfectly well established that the construction of such commitments must be liberal in support of the lawfulness of the exercise of the jurisdiction, when considered on returns to the writ of habeas corpus. Section 297. Errors, irregularity, and jurisdiction. Mere error or irregularity in these judgments cannot be reviewed, any more than in other judgments. The writ of habeas corpus is not for such a purpose. Any objections in error, it has been said in England, appearing upon the face of the return will not be reviewed on habeas corpus if it is found that a sentence has been pronounced by a court of competent jurisdiction to inquire into the offence and with power to inflict such a punishment. All else will be presumed omnia right acta. In the United States, where it is generally competent for the prisoner to controvert the facts stated in the return to the writ of habeas corpus, he may, says Mr. Justice Salvi, of the Court of Appeals of Maryland, if he can, show that there has been no conviction in fact, or that it is simply void for the want of jurisdiction in the magistrate to make it. But if he desires to go behind the conviction recited in the warrant of commitment to question the regularity of the proceedings upon which the conviction is founded, or to impeach the conviction itself for errors therein, other than the want of jurisdiction in the premises, he should bring up the record of conviction by certiorari for examination on the return of the habeas corpus. But where the justice has jurisdiction of the offence, with the power to try, convict, and commit therefore, and the commitment recites the conviction will be presumed lawful until the contrary is shown. Upon no other principle could proceedings of this character be made effectual. As a general proposition, therefore, in such cases, mere errors or irregularities, if there be any, committed by the justice within the sphere of his jurisdiction, cannot be inquired into collaterally on habeas corpus. The writ of habeas corpus cannot be made, unless it be by express statute, to perform the functions of a writ of error, in bringing under review a judgment or sentence of a competent tribunal, simply for errors or irregularities in the proceedings or in the rendition of the judgment or sentence, that must be done by some more direct and appropriate proceeding. An imprisonment under a sentence by a court or magistrate of competent jurisdiction is not unlawful, unless the sentence, for some cause to be made apparent, be not merely erroneous, but an absolute nullity, though if it be shown to be such nullity, the party is entitled to his immediate discharge. Point 1. Section 298. Statement of proceedings on face of commitment. Where a prisoner was committed by a justice of the peace under a warrant of execution, which recited that he had been convicted, etc., upon return to a writ of habeas corpus, it was objected that the warrant of commitment did not state on its face all the proceedings prescribed by the statute, to which Chief Justice Abbott, speaking for the court, replied, "We are bound to presume, until the contrary is shown, that there has been a good conviction, and that the magistrate has done everything required of him by law." And in the conclusion of the opinion he said, "As we are bound to presume that there was a good conviction before commitment, I think we ought not to discharge the defendant." The distinction was made in this case between the record of conviction and the warrant of commitment, and the Chief Justice acknowledged his difficulty in subjecting the warrant of commitment to the same rules of construction applicable to convictions. "This," said he, "is a commitment in execution, and recites that the party has been convicted, and there is no distinction in the cases cited which authorizes us to look at the warrant of commitment with the same strictness of a conviction. The commitment is for 2 months unless the money shall be sooner paid. I think it is not necessary that the commitment should state to whom it should be paid. If the defendant pays the money over to the jailer, he will be discharged forthwith. It is not suggested that the magistrate did not direct to whom the money was to be paid before the conviction took place. 2. The commitment will be considered a true recital of the conviction, although the commitment may be defective, unless the conviction be removed either by appeal or certiorari for the inspection of the court exercising a supervisory revision. In New York it is held that the commitment is sufficient if it follows the record, and when it is not required that the justice should insert in the record the particular grounds on which the charge of vagrancy is based, it cannot be necessary to recite them in the commitment. The words defining the particular cause of vagrancy may therefore be regarded as surplusage, and the charge of being a vagrant and being committed therefore is sufficient. All the facts necessary to constitute the offence in summary convictions should be proved, but it is not necessary to recite them all in the commitment. In main, complaints need not contain a recital of city bylaws on which they are founded. Section 299. Conviction without authority of law. But the magistrate cannot travel out of the statute and declare that to be a crime which is no crime, or disregard the description contained in the statute and classify persons according to his own judgment. Thus in New York it is held, that satisfactory evidence that a female is a common prostitute and idle person will not authorize her conviction as a vagrant under the statute. The statute does not declare common prostitutes as a class, or by name, to be vagrants, nor does it declare all idle persons to be vagrants, but only such idle persons as live without employment and yet have no means to maintain themselves. There was no such common law offense or crime as vagrancy and idleness, and to commit one for such an offense who does not come within the description of the statute is without authority of law, and void, and the prisoner will be discharged. Section 300. Security to keep the peace. Except as otherwise and further provided by statute, the common law rule should at least be followed. This provided that a warrant of commitment for an offense must upon its face show the cause of commitment and the nature of the offense charged, so far at least as to show that the same was within the jurisdiction of the committing officer. And where the commitment is not for an actual offense, but merely to obtain security against an apprehended offense, their warrant must upon its face show the cause of committal, that is, the direction of the magistrate that the party shall find surety, and the neglect of the party to do so. The complaint, where the object of the prosecutor is to obtain surety of the peace to prevent the commission of a crime, must be in writing and upon oath. It is intended to be a separate and distinct proceeding from the examination of the complainant, for the purpose of ascertaining whether that written complaint is well founded. Before such a complaint in writing has been made, the magistrate has no jurisdiction to administer an oath to the complainant, or to his witnesses, for the purpose of ascertaining whether there was reason to fear the commission of the anticipated offense, and the complaint and the subsequent examination of the complainant cannot properly be contained in the same paper. If, however, the warrant to arrest recite that there was a complaint in writing and upon oath, it will be prima facie evidence that such proceedings were had. This will protect the magistrate in an action against him until the party denying the jurisdiction which depends on that fact shows the recital to be false. It is not necessary, however, to state in the mittimus the crime for the prevention of which the application for sureties of the peace is made. It is sufficient to state the refusal to find sureties against future anticipated breaches of the peace. Upon a conviction for disorderly conduct, the making and filing of a record is not necessary, but if it were, it seems that the omission to file one would not be ground for discharging the prisoner upon habeas corpus. It is also held in New York that it is not necessary, in a commitment for disorderly conduct, to set forth the particular act complained of, and that a commitment for such offense, until the party shall find security for his good behavior, without qualification, is void. This was the common law rule. But here the time of imprisonment should be limited to the term specified in the statute. In that state error, irregularity, and judgments founded upon insufficient evidence may be assailed by certiorari, but not by habeas corpus. In Florida, sureties of the peace against doing damage to property, except as to threats to burn a dwelling house, are not authorized by the common law or by statute, and imprisonment for want of such sureties is not allowed by law. So where one was held in custody on the warrant of a committing magistrate, for want of sureties against doing damage to the property, and to keep the peace toward the complainant, where it was stated in the complaint that the accused had threatened to do damage to a schooner, the proceeding was regarded as without authority of law, and the cause remanded that proceedings be had according to law.